Net feature. Good. Well, item number 1 can it be taken up at 2 o'clock?
This matter parted.
Yes. No.
It is not parted by
It's not parted, I think, my lord. No. Lordship, party matter on 50 occasions. And was take thereafter my
this matter is tagged.
at 2 o'clock.
Why? What is the urgency?
There is urgency, my lord. We have been prevented from entering.
That's good, but you have been taking all along very many times up there.
So
All
on
along.
1 or 2 occasions we have taken.
There have been 5 occasions, 4 occasions you have taken. 15 to 2024, 1 to 2024, 18, 12, 2023, 15, 11, 2020. So that's 6 dates, of which 4 dates you have taken. Because you see, this court is only taking
My
up.
lord, our only anxiety is not to recollect this case, my lord, as a precursor to our entry, to prevent our entry, that criminal proceeding was in. Now that criminal proceeding stands quashed. Now, my lord, they have invoked that particular clause of the act. Question is, my lord, it is
Which on the face of it is not correct.
it is the joint action committee who is competent to take it. My lord, this is a malafide, it's a malice in law is on it's clear on the face of it.
That's
Just
true.
to prevent our entry, they are doing all this.
No,
In
it
fact,
is,
their lordship has said that no coercive measure will be taken. In spite of that, they are not permitting us. And on the contrary, my
no,
lord,
no. The question
My
now we are concerned with the termination.
I mean,
The termination has been done. If I remember, clause 9,
9,
which states a particular thing
it
has
has
to
become unviable,
unviable, and the unviableness has to be.
assessed or determined by that committee, my lord,
Oh.
not by the DFO.
Mm.
That's
Well,
why lordship has said no coercive measure would be taken, meaning that we should be allowed entry. In spite of that, the lord could clarify that hearing can take place some other time. That prevention part can be, my lord, taken.
No, then I'll finally dispose it of only. Take it up at 2.
If you
Item number 3 and 4, that review better. Can it be after 3 weeks? They thought for some time because of the year ending manner, the final demand is the allotment of funds and all.
I think you need to do something because what has happened out here,
Well,
it's okay. What is transpires from an affidavit is you have just put the blame of the burden on the court. One thing one has to take note of that if in all other ministerial services, you require that there has to be a degree.
But
now also, if it is done also, it can be very well done.
in fact, it rule has been amended in 2015 manner. Prior to their promotion. So
The question is, they have taken up the plea out there, like
Yes.
Mr. and Mr. Sahu.
got
Is to that effect that rule has been amended, but that amended rule has not been applied. Isn't that? So
Right.
therefore, isn't it? And what have you stated in your affidavit? You say in the affidavit, we were unclear.
Right.
But with the judgment of the court, now we are clear.
Yes.
So I am not putting the entire burden on this. As if this court has been legislated.
that's why
Let's
Lordship has
stand
thought
However, it's not inspired.
Right.
Because you need to.
Some notification adopting the new minor.
If you don't do that, so this court can very well say to the effect that yes, this court would not like to review the thing because this is the whatever it is. Those aspects of it. But that was not whatever it is.
Even what the government say, madam, because they are the authority will
Take a decision on that. We'll
Yes.
have it after 3 weeks.
after.
The request of Mr. Pikuko is the latest. Finance, 28/3/2020. Now don't come up later on the election declared, so we don't have
No,
time.
no, but in first week of April, madam. It is 31st of March, after 31st of March.
What is there with 30?
So financial year ending, madam, they will be, madam, they are busy for that purpose only.
Let it be on 9th of
I am obliged, madam.
Of case, testimonial appear any date is month of March.
matrimonial appeal.
Here, where respondent wife
You want it for what?
listing of
Why?
stage 2 with this basic alternative.
Motion, admission, or which one?
Here,
Ah, take it up with the race.
With the consent of the other side, I beg to mention item number 22. But the respondent has expired. You have to substitute. I'm for the petitioner. So
Item
sometime
number
22, supplementary.
yes. What do you want?
But the respondent has expired. Sometime may be granted so that we can substitute.
You are the
Petitioner.
plaintiff,
Petitioner.
appellant.
Yes, ma'am.
When did the respondent die?
But in the month of January.
It is within time.
Waiting, sir.
How do you know?
But I have received the death certificate.
Huh?
I have received the death certificate.
You have it?
Not yet. Another file.
Where have you received it?
But 1 week.
Produce the death certificate at 2. You have it? Because then I'll pass it to your order.
Public.
Yes, ma'am.
I pray for listing 2 cases, my lord, because 4 analogous cases within the same order, your lordship has disposed it of as non-maintainable. So I want that the other 2 cases also may be listed or
For
because
order,
or
motion, admission, which one?
for order. We have got tomorrow. We have got
Why?
any
No, no,
day
no, no.
on
Have
Friday
it on.
or Friday night.
You
Right.
want a Friday, I'll give you a Friday on 22nd of March.
Lord.
22nd of March. That's a Friday. For orders, huh? Not for hearing with.
The concept of other party, I would like item number 30.
What is it? Huh? This matter may oh, 2013 matter. No, I don't. There's no adjournment business on it. Don't ask for it. Yes, next.
I at five there at the one. The what then I five at so what and X one I five for and X product the first one there is the
Hello. Have it next.
it for the
26.
apply and one paper not what
Will come. File it. Normally come.
file it on
I don't
one
see
page.
motions before me now. They will
1 step 5.
The serious thing is that there must be some defect. 1P, they the subject. You take it up before the review.
Appellate.
I beg to mention for listing lordship on I and CRP
For what?
for order lordship.
Just take it. Mr. Manan, whether the Union of India is a party in this?
Union.
No.
The state of Assam is
Huh? No.
State
We
of-
have to let us make Union of India. Because without Union of India party, to give an effective relief, see, give you the relief, it is one thing. But one has to also take note of the SBI. Because the SBI is also something has to be there because there are two regulations. One is 2000 which we have, and the other has come in 2020, another deal. So these two categorically mentioned, these are all done under the DOT. And the DOT has directed that need to apply immediately, and the other we need to. So we have to ask as to from DOT as to these actions, whether these actions based on to let us get them. Then it would be helpful for the SBI to get them from here. Because this has a far-reaching consequence with the team swapping. Because you see what they have done, they have been negligent. Airtel has been, they could not have done it because has a far-reaching consequence. I think it needs to be set addressed by past. We'll have the union of you get a union of yeah. The instant requisition has been filed by the petition.
like for your lordship. One to the ERA the act. There basically ERA has the power section 12 of the act to ask whether the company of telecom operator
No,
or
no,
inquiry.
Mr. Manan, I've understood that. But the problem arises where do you know whether upon a direction passed by this court, can the TRI proceed with
Yes.
there? In order to do that,
Yes.
you have to link the dot.
So the
Then if you link the dot, all the dots are combined together, you have the link.
I understand. I was just pointing it.
Because I thought about it, the
So
only
just I
way
was
out.
researching as per your lordship.
Huh?
As per your lordship's direction that I was just researching. And one more thing I found that the IT Act of Section 43A, IT Act of 2008, Section 43A has been found. There they have stated if your lordship is correct, because in that case also say that if there are some directions or the notification circular of the central government, it has not been done, then they are entitled to take up. That is there. So your lordship is very correct. That is why I have seen that in 2008, 43A. 43A says, and the explanation says that if there is a violation of the directive itself.
So therefore, there you can bring it.
Yes.
Once we bring the dot,
That is
Let us hear it first. The instant petition has been filed by the petitioner. Who is the pensioner? He is a pensioner. With the pension being agreed by the fraudulent withdrawal of an amount of rupees 8 lakhs 90. How much it is?
8 lakh 9 8 lakh
Petition
8 lakh 95,000
Huh?
895040.
8 lakhs 95,040 from its savings bank account. Bearing account number
1095.
109,582,25308 of maintained in the State Bank of India, Rongia branch. From the investigative report, which was carried out pursuant to an FIR filed by it revealed there's a year of the
That your lordship at page 29.
date.
The date.
This is the year forwarding
because
report.
the
No.
charge sheet
Some
has not been-
investigation was carried out.
Yes, the charge sheet has not been checked.
Not the investigation was carried out pursuant to the filing of the FIR. It reveals that the police had arrested 5 persons and had forwarded them to the judicial custody. Who is respond number 6, 7, 8, and 9? You, na?
I am
It also is apparent from a perusal of the affidavit in opposition filed by the respondent number 6, 7, 8, and 9. That the said amount that on 3/10/2020 and 4/10/2020, various transactions were carried out in the petitioner's account. Resulting in the balance, available balance being rupees 69.61 paisa. Whereas on 2/10/2020, the balance in the account of the petitioner was rupees 9,13,006.54. It was further mentioned by the SBI in the affidavit that 9 internet banking transactions totaling to 7,70,024 were made between 3/10/2020 to 4/10/2020. And there were 3 UPI transactions of an amount of 5,000, 50,000 and 50,000 between 2/10/2020 and 3/10/2020. It is further mentioned that these 9 transactions, internet banking transactions, were carried out with the help of secure OTP, bracket one-time password, which was successfully delivered to the registered mobile number of the petitioner being 99544 64365. Further to that, it was mentioned that all frauds were merchant-based transactions where the funds were remitted to a merchant, inverted comma, quick silver solutions, inverted comma, close, a third-party transaction. And there were 3 unauthorized UPI transactions amounting to rupees 5,000, 50,000 and 50,000 on between 2/10/2020 to 3/10/2020. It was mentioned that the petitioner had compromised his secret UPI PIN to the fraudster. Further to that, OTP is not required in the UPI transaction, but only the secret PIN is required to log in to the UPI application. This court have also taken note of Annexure A to the said affidavit filed by the SBI authorities. Wherein, which is the statement of bank account of the petitioner. The record further repeats that an additional affidavit was filed by the SBI authority pursuant to directions passed by the court on 20/10/2023, stating inter alia as to how internet banking registration can be activated without branch visit as per its circular number NBG-INB/1/2015-16 dated 28/4/2015. A perusal of the said affidavit, more particularly paragraph number 3 of the said 3 and 4, would show that in terms with the said circular dated 28/4/2015, internet banking registration could be activated without branch visit. You did not have an internet banking. This court also finds it very pertinent to observe herein that the petitioner, prior to this incident, had never resorted to use the internet banking.
I have mentioned paragraph 3 of my.
It is also very pertinent to take note of that the mobile number which was used by the petitioner for his banking transaction with the SBI was in the name of his daughter, one Tulika Deka. For the period from 1/10/2020 na, to 4/10/2020, the SIM card used
One second.
from 2/10/2020 to 4/10/2020 as the SIM card used in respect to the mobile number in question was not working. The daughter of the petitioner had lodged the complaint with the Appellate authority on 4/10/2020. This aspect of the matter is evident from the affidavit in opposition filed by the respondent number 10 and 11, wherein they had enclosed the Airtel prepaid enrollment form of the said Tulika Deka and the document used for the purpose of verification and the document used for the purpose of her identity. To the said affidavit, an application has also been enclosed of a fraudster impersonating herself to be the Tulika Dekar, which application was filed on 1/10/2020. Along with that application, an elector voter's identity card of the said person impersonating the daughter of the petitioner was also enclosed. At this stage, this court finds it very pertinent to take note of that in the original application filed the address of the said Tulika Dekar was mentioned as village Murara, Rongia. With the date of birth as 11/4/1990. However, in the application filed by the person impersonating the daughter of the petitioner, her address was mentioned of village Hiragota, and in the application, the date of birth was mentioned as 1/1/1985. Apparently, both the identity, both the identity identifying documents did not match with the date of birth as well as the address. It is also relevant to take note of that on 4/10/2020, when the daughter of the petitioner went to lodge the complaint, and submitted another application for SIM swap on 4/10/2020. Another electoral identity card was enclosed of the daughter of the petitioner. Where the address was categorically mentioned as Hirait Murada, T.S. Rongia. And the date of birth was mentioned as 4/10/1998. It is very pertinent to mention also that these details, which have been inserted in the application, enclosed as Annexure A to the affidavit filed by the Airtel authority, have been done by the Airtel authority as they had the control to insert those details. This court have further taken note of a circular issued by the Government of India Ministry of Communications, Department of Telecommunications, dated 1/8/2016, which was an instruction issued by the Government of India for issuing new SIM card in case of swapping, replacement, upgradation of SIM card. Clause Roman 2 and Roman 3 of the said instruction being relevant is reproduced herein under. Page 137. From the above quoted instructions, it reveals that the person at the point of sale, meaning thereby the Airtel authority, has to match the copy of the proof of identity document submitted by the subscriber with its original, and also record a declaration on it along with his her name, signature, date, point of sale code, and point of sale stamp containing address, to the effect that the person at the point of sale has seen the subscriber and matched the copy of the point proof of identity document with its original. only after the said activity a SIM card may be issued to the subscriber. There is a further additional check which is required to be carried out, and the same has been mentioned in clause Roman 3 of the instruction dated 1/8/2016, which mandate that before activating a new SIM card, the employee of the licensee, meaning thereby the employee of the Airtel, who is activating the new SIM card, shall verify that the details of the proof of identity document submitted by the subscriber are matching with the records available with the license, and also record a declaration to this effect on the copy of the proof of identity document under his, her name, comma, designation and signature with the date. This court, however, failed to understand that when the address mentioned in the identity document, which was in the records of the Airtel, categorically mentioned the date of birth to be 11/4/1990 and the address to be village Murara, Rongia. How could the employee of the Airtel Limited of the Airtel could have recorded the satisfaction that he had matched with the record, and the same was and give a declaration that too when the document which was submitted for SIM swapping on 1/10/2020 categorically mentioned the village as Arata. Is that? Huh? Oh, no. Village Hiragota. PS Rongia. And the date of birth mentioned in the application was 1/1/1985. Hey, this court have duly also taken note of that in the instant case, the petitioner is seeking recovery of the amount which have been fraudulent withdrawn from his account. And taking into account the circular of the Reserve Bank of India dated 6/7/2017, this court prima facie is of the opinion that clause 7 Roman 2 of the same application, clause 7 Roman 2 along with clause 8 of the said circular may be applicable to the facts of the instant case. This court have also taken note of that the petitioners herein have alleged infraction to the circular of the Department of Telecommunications, Government of India, dated 1/8/2016 by the respondent number 10 and 11. Therefore, for the purpose of a proper adjudication of the instant petition, proper and effective adjudication of the instant petition, and also taking into account that this SIM swapping have become a menace in the banking, resulting in various bank frauds. This court is of the opinion that the Union of India, represented by the Secretary to the Government of India, the Union of India, represented by the Secretary to the Department of Telecommunication, Ministry of Communication, having its office at 12 Panchar Bhavan, 20 Ashoka Road, New Delhi, 110001, is required to be made a party respondent to the instant proceedings. Accordingly, the said to Union of is arrayed as the respondent number 12 to the instant petition. The petitioner herein is directed to file an amended memo of parties before the court below, before the registry of this court by 15th of March 2024. And on the basis of the said amended memo of parties, along with the instant order, the registry shall make necessary correction in the cause title of the petition and also update the same in the CIS. Mr. C.K.S. Borua, the learned counsel, learned CGC, who being present during the course of the hearing, who was present in the court, had accepted notice on behalf of the newly impleaded respondent number 12. This court directs the petition to serve the copy of the entire pleadings to Mr. C.K.S. Borua, the learned CDC, by 14/3/2024. Mr. The respondent number 12 is directed to apprise this court on the basis of the materials on record as to whether there has been a violation by the respondent number 10 and 11 to its instruction dated 1/8/2016 on the next day. This the matter again when again. Maybe the second of proponent.
Second April.
Airtel Gurot, Airtel Billy Koitu, respond number. Airtel is respond number 10 or 11.
10 and 11.
There can't be both. One.
RT Airtel.
Because Airtel is a brand. Airtel kore bhal no. Response number what? 10 or 11?
RT Airtel 10.
10.
Yes.
So what is 11?
11 is the Northeast, Airtel Northeast.
Airtel notice has something else. There's no Airtel. 10, huh?
10.
10. You got Airtel billy go to response number.
Complete. NCR has been received. It should be in hearing column.
Huh? How did the matter come? Prioritize in talk.
It is fixed matter, but it should become hearing column.
LCA has been received 2018. What is the point of law? Let us see.
So better. And first of
Whether it was justified in dismissing the suit by holding that the same had abated by operation of court notwithstanding in place of the event or whether the participation the file of the amount giver. Just tell me what is the first point of view? What is the first point?
My
Let us see the trial court order.
Well, so substantial question is there. The good property is undivided. So one of represented. Son is not made party or yourself. That is why it's abated. Partially it may be abated, but it should not be abated completely. And there is a law that if one representative undivided property, one can represent the other itself to represent that question.
Yes. What is wrong?
But, they, when they progress
You
towards-
don't have a case.
So,
Yes, on the first point, abatement couldn't have happened, but on the ground the non-joiner of necessary party, you can't escape. You don't have a case for non-joiner of abatement is okay. One can take a very liberal approach in view of Amrit Karla's judgment out there, Amrit Singh. One can take a liberal approach, but Amarjit, but how do you take care of not completing Anil Rao?
Neil,
There it becomes fatal.
one day maybe things I have not position to get.
What?
They, my senior, that
Who is your senior?
if you put that first, is the, and brief is not need with.
Huh?
I think order is there that judge for hearing they will be fixed. So he said that it may be fixed and he come with deliberate and force people answer.
Is there any stay?
No stay.
No stay.
That may kind of answer. That may be fixed. That's what we do.
Okay. At the request of the learned counsel appearing on behalf of the appellant, taking into account that the LCI has received the list matter for hearing in its usual course?
No, actually. In month of April,
Absolutely no.
after Bihu,
In the usual course. There are 2000. Today you was a chance to get the dismissal, you didn't.
All right.
You will be happy. You are in possession.
Hello, 5 for here.
Yes, I.
May I please look at it?
What are questions of law?
My lord, on 3/8/2009, my lord.
Whether the
Fourth
suit
question,
for
sir.
declaration, eviction, partition, and possession together with permanent to first simply pass an order for declaration of title and thereby sending
The parties.
the yes. What is your issue?
My
Let
lord,
us see the judgment.
transport, my lord.
Why do you need that? Yeah. Let's see the appellate court.
Yes,
What
my
is
lord.
a plaint? Where is a plaint? To me,
Yes, my lord, plaint is at page number 79 to 84.
is that
Amended plaint.
you are the defendant.
I was the defendant.
What happened to the other side? Out of fear, you are appearing.
No, my lord, they had appeared, my lord.
Then
My lord, as per the
their names
order,
have been shown.
one
So,
14/9/2009, my lord.
Eh?
On 14/9/2009, Wakalatnama by Mr. R.P. Sharma and Kaveri Dikshit expired.
their names are shown. A suit for declaration of right title and interest for eviction and
For partition, for
who is the plaintiff?
plaintiff is, my lord, one of the purchaser from the same Dagan Patta from I have. My lord, in fact, there are two dags
Hmm.
pertaining to Patan Button, District Raj Patan Button, my lord.
Plaintiff is
Tag
the
number-
owner of 17 lectures of land out of total 1 bitha, 1 kata 15 lectures. Yes. So you admit the plaintiff is the owner of 1 kata 14 lectures?
Yes.
So now the question arises is the court decreed the suit for delivery of possession only in respect to Schedule B.
Yes.
Whereas Schedule A is the total land of 1 kata 14 lectures.
Yes.
He wants a partition that this 1 kata 14 lecture should be brought out and issue the separate patta from patta number 2.
Pattern number 2. Yes,
That's it.
Yes.
So what is wrong with the order?
my lord. Instead of the court doing it, the court has directed the same to be done by the revenue authority.
The revenue
the-
authorities can only make the partition.
Yes, partition. But my lord, if your lordship wishes to peruse the court witness who was the Amin Commissioner, my lord, their Amin Commissioner has reported that according to the map, my lord, tag number 3268, instead of containing 1 katta 15 lecha of land, is containing only 1 katta 12 lecha of. And tag number 3269 instead containing 1 katta 14 lecha of land.
That the Amin Commissioner will do at that point of time in the partition, whatever land is available. That is another aspect of the matter. But the fact that
Yes.
on the basis of the deeds of sale, which have been produced before the learned trial court, it has been found that yes, the petitioner, the plaintiff is entitled to 1 kata 14 letters, of which 17 letters of 3268 and 3269.
My lord, my lord, if they are
And
going
you
to-
are in only possession of the land by 5 feet into 45 feet.
No, that is the commissioner's report also, my lord. Sheet of 2 my lord.
Schedule B is 5 feet by 45 feet.
My
Let
lord,
us see how the trial court decides that aspect.
trial court judgment, my lord, is from page.
Page 50. Right title and interest, yeah, 4. Number 3. It do not conflict, but You purchase subsequently.
I am a subsequent purchaser from the same owner from whom the plaintiff have purchased.
And the sale deed which the plaintiff has purchased categorically shows 17 lectures and 17 lectures.
Yes, ma'am. Correct.
And 3269 has how much land?
It is 180 square feet, 1.5 acre. 1 acre and
No. 3269 and 3268. How much land is there?
32, my lord.
3269.
3269, my lord. Total land is 1 kattha and 14 lecture.
Okay. But
That
if
is
you, no,
complete land.
therefore the question arises, he has 17. The remaining 17 is yours.
Right.
And in the second is also 1 katha 14 lecture.
No, 1 kattha 15 lecture.
15 lecture, of which
Out of which he is having
17 is yours.
Yes.
18 is yours.
Yes.
18 is yours.
18 is mine.
Now, if there is less land, what happens?
My lord, then according the map is required to be corrected according to Chitta, rightly pointed out. Because Chitta contains the bigger area of land than that of the map. And that what is the report of the Amin Commissioner of.
Oh. Hey. Where is issue number 4 decided?
Issue number 4 in that way not separately decided, my lord.
So he says out here.
But issue number 4 is pertinent whether the plaintiff for the degree of cash position on the each land by evicting the plaintiff.
No. You see the trial court's decree. He's also entitled to page 54.
Yes, my lord.
He's also entitled to the degree of first possession of the Schedule B land, subject to the partition made by the Revenue Authority.
Revenue authority, yes.
So first the partition will be made, and then the possession will be delivered.
Yes, but for that, my lord, that area is required to be corrected. That's what I am saying, because Amin Commissioner was appointed by the learned trial court. Amin Commissioner has clearly reported that according to the Chitta, map is not prepared. There are 3 lecture land lesser than that of the Chitta map.
So then why not 48 will come in? You are the second purchaser.
Yes.
Then if you are the second purchaser, your right will be subject to the right of the plaintiff.
My right would be subject to the right of the plaintiff, my lord, that is there. But when the Amin Commissioner has already reported that it is required to be corrected, according to that, my lord, I am agreeable to that. Let the area be brought.
Amin Commissioner is not the person to say what is to be done or what is not to be done. He has no business. He is only a witness.
No, but he has pointed out clearly, my lord.
He
that
cannot
the
do
map
all
is-
these things.
map
You see, the first and foremost is the plaintiff had purchased the land of 1 katha 14 lectures and 17 lectures each.
True, my lord.
Now, if any land is not there in that particular dark which have been sold, the deficit has to be yours.
But my lord, the total land is more than that. 3 lecture more than that. Kindly have a look, my lord, at the Kumar Roy's report.
No. Well, I'm not on that. I'm only asking whether these dark number 3269,
Yes, ma'am.
as per the Chitta, has 14 lectures of land.
1
1 katha 14 lectures.
True, my lord.
So take it up with the race. Once the matter has gone to the partition, take it up with the DC. What is to be decided? How to do it, what not to do. What is wrong with this judgment? There's no wrong. It has been said that the partition, recovery of cash possession will be subject to the partition. They will make the partition and give it to them. Nothing wrong in this thing.
Then that I am agreeable to that direction.
So you
Lord.
take it up with before the DC. The DC has to be told out there. Then look here, the DC says this is what it is. You are therefore to take in note of the law is well settled and the judgment does not appear to be wrong. The trial court. I have not seen the appellate.
No, in the trial court, my lord, when the
What did the
partition was,
appellate court do?
when the partition was short, similarly, the appellate
Affirm.
court has
So
also.
the relief remains.
Yes.
So the recovery of khas possession is subject to the partition. So how does your substantial question of law arises?
Delivery of past position is subject, yes, my lord, true.
Here it is says he is also entitled to the decree of khas possession of Sidra subject to the partition made by the revenue authority, which means it will be subject.
Yes, only
Then-
after that, yes.
Then
But-
how is it wrong?
But there is no preliminary decree passed to that effect.
Not
when the
why do you
partition
require
is
a
short.
preliminary decree? You don't require a preliminary. The partition is to be done by whom?
By the collector, my lord.
You see, section 100, if I am not wrong, is a thing when a person can very well apply for partition before the DC. Now, once the DC, when you apply for partition before the DC will normally partition it. But if there is a dispute as regards title,
Yes, yes,
then in that case, the DC will refer to the civil court.
Correct.
Here is a case where the civil court has categorically held that here the plaintiff is entitled to 1 katha 14 lectures, of which 17 lectures and 17 lectures. And thereupon, the other side, whatever remains is yours.
my lord, I am also the purchaser of equally.
Understood, but that is subject to 48. You can't help it. You are the second purchaser.
I'm the second purchaser.
So therefore, the court has already found out that he is entitled to this and he is entitled to that.
But the court has also found out, my lord, that I am in lesser area than that of the
Court
purchased
has
area.
found out maybe you are lesser, but that has to be partitioned by them. Still partition. And then once that partition is done, it will go for recovery.
So, my lord, may I pray that partition must be according to Chitta?
Why should I say that?
My lord, according to Chitta, definitely
Why
because
should is it
because
that
Paresh
No,
Chandra
Mr.
Majumdar had-
Sattar, whether it is the partition is to be done as per the Chita, it is for the DC to decide. That is not the subject matter of this court.
or as per the Jamabandi, my lord.
It is one and the same thing.
No, no, not same, my lord, because Jamabandi is the final.
It is
thing
one
of
and the
Chitta.
same. You don't have a case. This is a case for dispute. The judgment has been rightly passed. I would have understood the preliminary decree would have come for other aspects. I'm coming in 5 minutes.
Preliminary or final decree is concerned, I am not on that, my lord. Both have purchased equal share of land from one person. And both are entitled to the equal share. If
Both
each-
are entitled, no. Both
No.
are not entitled to the equal share. That will be subject to the share remaining of the vendor after the sale being made to the plaintiff.
equal share remains fine.
That will be subject to the land remaining with the vendor after the sale made to the plaintiff.
Yes, ma'am.
If he has, it is has.
So, my
That
lord,
is for a DC court to decide.
that is true, my lord. 3 kattha 19 lecha is the land of district Raj Patta number 2. Out of that, my lord, 17 and 17, 1 kattha 14 lecha he has purchased. 1 kattha 14 lecha I have also purchased. The area which is shown there is 3 kattha 9 lecha. But in the map, my lord, the area is shown as 1 lecha less in 3269 and 2 lecha less in 3268. 326.
So that is subject matter of a writ. Not.
And my lord,
This is an
one more-
appeal.
What was the reason, my lord?
Yeah.
Has there been a preliminary decree?
There's no
Then
preliminary
everything would have
decree.
come up.
No, it is not required. The 54 it can be done. Order 28. Still it-
Because my learned friend is saying that go to your lordship, that Mulchan's case. That is the remember.
Multan case is
that
there,
is well
but the
already
Multan
in the
case is
memory
of a
of-
different aspect. But here is the case which is not required because the court had clearly identified that he is entitled to 2 kata. Or what kata, what is that? Whatever. 1 kata 14 lakh.
14 lecha, yes.
So in these 2 lakhs, the city is to go look into it and then there are. Now after that partition, if it happens, if he wants for execution, he has to go for the execution on the basis of what partition is not required that this particular thing. You see, kindly see the back is very clear. The instant repeat under section 100 of the Code of Civil Procedure 1908, for short, the code is directed against the judgment and plea dated 18/3/2009, passed in title appeal number 43 of 2007, whereby the judgment and decree dated 19/11/2007 was affirmed by the judgment and decree dated 19/11/2007, passed by the learned Munsif number 1 Corpeta in title suit number 167 of 2005 was affirmed. This court, by an order dated 3/8/2009, had framed 4 substantial questions of law. Have framed substantial questions of law. Have admitted the infinity framing 4 substantial questions, which are reproduced herein. For deciding as to whether the state substantial questions of law arising are involved in the instant appeal, this court finds it relevant to take note of the relevant facts involved, the relevant facts in front. The respondent herein, is he alive or dead? The respondent dead. Here the respondent,
Yes, ma'am.
is he alive or dead? The plaintiff is dead.
Right.
Original plaintiff, you are having now respondent number 1 and 2.
Who is that committee man? Perfect.
The respondent herein, as plaintiff, has instituted the suit being title number 167 of 2005. From a perusal of the plaintiff, reveals that the plaintiff had purchased a plot of land measuring 17 lesser from tag number 3268 of NK Patta number 2 of Borpeta Town. The same tag number 3268 contains a total land of 1 kata 15 acres. In addition to that, the plaintiff had purchased another plot of land measuring 17 lesser from tag number 3269 of the same NK Patta number 2. The same tag number 3269 contains 1 kata 14 acres of land. Therefore, as per the plaintiff, he was the owner of 1 kata 14 acres of land covered by both tag number 3268 and 3269, which were contiguous in nature. The said 8 land is more specifically described in 8 the plaintiff. It has been alleged in the plaintiff that the defendant trespassed into the plaintiff's land to the extent of a portion of land measuring 5 feet into 45 feet. The said land have been more specifically described in under such circumstances, the suit was filed by the plaintiff seeking declaration of his right, title, and interest over the suit land. Semicolon. Decree for class possession of the Schedule B land by evicting the defendant. Semicolon. Permanent injunction restraining the defendant from re-entering into the suit land after being evicted and from disturbing the plaintiff in the peaceful possession of the suit land. In addition to that, the plaintiff also sought for a decree for partition of the Schedule A land from the NK Patta number 2 of Borpet Town. The same suit, upon being filed, the defendant filed a written statement admitting inter alia the plaintiff and the defendant are co-sharer of the dark number 3268 and 3269, and the shares have not been partitioned. It was denied that the defendant had trespassed into the plaintiff's land. It was also duly admitted in the written statement, more particularly at paragraph number 9, that the plaintiff though have claimed to have purchased a part of dark number 3268 and 3269. The rest part of the dark number 3268 measuring 18 letters and the rest part of dark number 3269 measuring 17 letters was purchased by the defendant by registered deeds of sale. It is, however, relevant to observe that the plaintiff had purchased, relevant to observe that the vendor of both the plaintiff and the defendant was one and the same. And the plaintiff had purchased his portion of the land prior to the defendant. On the basis of the said pleadings, the learned trial court framed as many as 4 issues, 4 or 5 issues, 5 issues, which includes the issue pertaining to declaration, which includes the issue pertaining to whether the plaintiff has right, title, and interest over the suit land, and also whether the plaintiff was entitled to the degree of class possession of the land by evicting the defendant. The learned trial court, after taking into account the evidence on record and applying the principles as set out in Section 48 of the Transfer of Property Act 1980, but that Transfer of Property Act 1882, came to a finding that the plaintiff had right, title, and interest over 17 letters of land in dark number 3268 and further 17 letters of land in dark number 1269 of NK Patta number 2. Further to that, the learned trial court observed that the plaintiff was entitled to the degree of partition and as such had directed the collector to partition the suit land. Further to that, the learned trial court, by the judgment and decree dated
1911, 2007.
1911,
1911,
2007, decreed the delivery of cash possession of the Schedule B land subject to the partition to be made by the revenue authority. It was further observed that the revenue authority shall partition the plaintiff's land at first, and if B schedule land is found encroached by the defendant, shall be evicted therefrom. The defendant, being aggrieved, had prepared an appeal before the first appellate court. Which was registered and numbered as cycle appeal number 43 of 2007. The learned first appellate court, after framing a point of determination, decided the appeal by affirming the judgment and decree passed by the learned trial court dated 1911-2007. It is against the same judgment and decree passed by the learned trial court on 18/6/2009. The present appeal has been filed wherein this court, by order dated 3/8/2009, admitted the appeal by formulating 4 substantial questions of law as already above noted. In the backdrop of the above, let this court therefore take into consideration as to whether the said substantial questions of law are actually involved in the instant appeal. The substantial questions of law so formulated at serial number 1, 2, and 3 are interlinked and in effect pertains to whether the learned courts below were justified in passing a decree for partition 1 and 2 are different. The effect as to whether the learned court below were justified. In passing the decree for partition, as well as a decree for past possession, at the same time, this could have duly taken note. The judgment and decree passed by both the courts below, wherein the learned courts below have categorically observed that the plaintiff has the right title and interest over 17 letters of land on dark number 3268 and another 17 letters of land in dark number 269 of NK Patana of Borpeta. The learned trial courts below having already asserted the said land, the share of the land of the plaintiff, had directed the collector, the revenue authorities to carry out the partition. Under such circumstances, the revenue authorities are required to carry out the partition in terms with Section 54 of the Code of Civil Procedure 1908, read with the provisions of the Assam Land and Revenue Regulations 1986, taking into account that the land of the plaintiff have been duly asserted. The learned courts below further had directed that first the plaintiff's land has to be asserted and partitioned, and thereupon, if it is found after partition that the Schedule B land falls within the land of the plaintiff, then to carry out, then the degree of past possession could come into play. This court, upon hearing the learned counsel for the petition appellant, and also taking into account the above provisions of law, is clearly of the opinion that these two substantial questions of law which have been alleged, which have been formulated, are not substantive questions of law involved with the incident. Now let this court take into account the third substantial question of law, which was framed as to whether the learned courts below were justified in sending the parties to revenue authority for ascertaining the disputed land after granting a decree on the basis of measurements made by the Amin Commission, as is evident from the Amin Commissioner's report. The same substantial question of law so formulated in the opinion of this court is totally misconceived on a reading of the court, the judgment and decree passed by both the courts below. Inasmuch as the learned both the courts below category had taken into account that the plaintiff was entitled to 17 acres of land in dark number 3268 and another 17 acres of land in dark number 3269. of NT Patra number the Amin Commission report could at best be taken as an evidence and nothing further. This court, the learned was below on the basis of the said Amin Commission's report and also on the extent materials of report had therefore directed the partition to be carried out in terms with section 54 of the Code of Civil Procedure of the Code. At this stage, this court finds it relevant to take note of the submission of Mr. A. Star, the learned counsel appearing on behalf of the appellant, who submits that a perusal of the Amin Commission's report would show that in fact the defendant is in possession of 3 letters less left, and then that of 3 letters, 4 letters of less left. And as such, the learned trial court ought to have, learned courts below ought to have taken into consideration the said aspect of that. To answer the said submission, the answer to the said submission can be dealt with. The answer to the said submission is there in the substantial question of law number 4. So formulated to the effect as to whether the courts below were justified in decreeing the suit invoking the provisions of section 48 of the Transfer of Property Act 1882. Though the Amin Commission appointed by the court had found otherwise. The provisions of section 48 of the Transfer of Property Act 1882 simply stated mean where that means mandates that when the vendor there's a Transfer of Property Act that
That section is also quoted by the Appellate Court.
the court has not started. The court has just repeated what the trial court verbatim written.
No, I'm giving that part.
Mandate that when a person purports to create by transfer at different times right in or over the same immovable property. And such right all cannot all exist or be exercised to their full extent together. Each later created right shall, in absence of a special covenant or reservation binding the earlier transferees, be subject to the right previously created. Under such circumstances, as the vendor of both the plaintiff and defendant are one and the same, and the sale deeds which were executed in favor of the plaintiff were prior in point of time, and there being no special contract or reservation binding the plaintiff, the right so conferred by the vendor of the plaintiff in respect to the land sold to the plaintiff would have a better right, would be subject to, no, would have a better right to the title so conveyed to the defendant insofar as the title conveyed to the defendant in any manner conflicts with the title conveyed to the plaintiff. Therefore, in view of the state statutory provision of law, the Amin Commissioner's report would not in any manner disentitle the plaintiff to the land to his share of the land to the extent the same had been conveyed by the vendor of the plaintiff. Therefore, the fourth substantial question of law in the opinion of this court is also not a substantial question of law involved existing. Under such circumstances, this court finds no merit in the instant appeal for which the state appeals gets dismissed with costs quantified at rupees 10,000. The learned a basic quit then they appeal. None appears. Okay. None appears on behalf of the appellant on call. The record reveals that the appellant had not appeared previously on 3 dates when the matter was called. Consequently, it reveals that the appellant is not interested in the proceeding for which the appeal stands dismissed for non-prosecution. The registry shall forthwith remit the LCM back to the trial in time order, if any. What?
Different court order.
Arrest, cost of protection, many.
How to appear yourself?
Huh?
How to appear?
Whether in view of the denial of tenancy by the defendant, the notice under there is required to be issued by the plaintiff before institution of the suit for declaration of right title interest in recovery. Is this a suit under Assam Agricultural Urban Area Agricultural Tenancy Act?
Yes.
Huh?
Yes.
Then wouldn't it be required under Section 11?
This is not a town area. This is not a town area, or village.
So Assam Non-Agricultural Tenancy Act does not apply.
Yeah.
Then we go by that constitution bench.
Yes. Yes.
And what is the cross of objection
Prosecution matter I have filed.
for what?
Okay.
How your cross objection has been admitted? How can a cross objection be admitted in this matter? It has to be also on a substantial question of law.
Yes.
Then?
Yes, madam. At the time of admission of the cross objection matter.
Huh?
No, sir. At the time of admission matter.
Then how is it possible to be admitted in this manner?
I have formulated the substantial question of law, my lord.
What are those?
My lord, page 4 of my cross objection, my lord.
Or whether the compromise plea is legal and valid? How can that be a cross objection? Substantial question. Whether the suit for declaration of title with respect to the suit land barred by 34. Why? What was the suit filed for?
They have filed, my lord, that on the basis of compromise, my lord, they got share, my lord, in some portion of the then, my lord.
Let us see the plain. Where is the plain?
I have annexed the plain, my lord. 5, my lord, page 5, my lord, amended.
Declaratory decree be passed. The plaintiff has right title and interest over the Schedule B land, and he has legal right to possess the suit land. Decree be passed. Ejectment of the defendant from the suit house mentioned in Schedule B in delivery of first. Suit house is where? Plaintiff has right title and interest over the Schedule B land, and he has legal right to possess the suit house standing there. Tell me. Now, did you raise the issue at that point of time when you filed a complaint under Section 34 in your written statement?
That point was.
Huh?
That point was.
Then you are covered by 61 Supreme Court judgment. It cannot be done. Can't raise that issue. That goes. Then, vitiated by non-consideration of the admission and exhibit of. What is this non-consideration? What is exhibit of? It's can't be a substantial question of law. It can't be framed in this manner. Right in holding the defendant did not acquire title by adverse possession. Okay. You claim to be adverse possession.
Yes,
Why?
because my lord, we are in possession of the land, my lord, since 1949.
Show me that in your written statement.
In the statement in amended written statement, page 17, my
Is 72.
17, my lord, of
Oh.
my cross of
No, in the main appeal. Is 72. You are the defendant.
yes, my lord.
Where is your statement for adverse possession?
My written statement starts from page 72.
That I've seen. Where is your statement for adverse possession? You filed a counterclaim.
Yes, my lord.
What happened to the counterclaim?
Counterclaim was dismissed, my lord. Counterclaim was
Dismissed.
Yes.
You filed appeal.
yes, my lord.
What happened to the appeal?
Appeal was also dismissed, my lord. Appeal was also dismissed.
Against that, have you filed appeal?
No, my lord, I have filed cross of
No. Cross objection is different. Cross objection is against any. Cross objection cannot be termed to be an. Cross objection is when there is an appeal, you want to support some of the issues which have been decided, or some issues you want to challenge, which has a bearing out there, then you do under Order 41 Rule 22. But the appeal which is required to be filed against the dismissal, because that is a decree, if you have not filed, so the counterclaim, you have not challenged it, cannot be on the basis of a cross objection. Cross objection is different. Cross objection is when you file, when the plaintiff files the suit, or whoever it is, the appellant files the appeal. Cross objection is only to support the decree which has been. The counterclaim cannot. There is nothing mentioned. Where is the allegation of yeah? Plaintiff has not complied with the provisions of Section 106 while serving notice.
this is the main issue.
Huh?
The other issues that have been
Now
studied.
tell me, well, how does 106 come in and your counterclaim both together? 106 is a lead.
Yes,
The moment you are saying that there is a requirement of a notice
Well-
under 106, do you
Well-
know the effect out there? The effect is you are admitting that you are a tenant, isn't it? What is 106? Your entire counterclaim thing is useless. Possible. 106. Duration of the lease. In absence of a contract or law for a lease of a immovable property of a demand shall be deemed to be a lease. So the moment you are stating that a suit is bad for non-compliance with 106, are you not admitting?
my lord, we are denied the tenancy.
Then why you are asking then the suit has not complied with the 106?
Both ways they have a
It's self-contradictory. If you have denied the tenancy, 106 does not come into the play. Then we have to decree that the substantial question of law duly arises. Tell me. They admit. Therefore, there is a substantial question of law. If you are denied the tenancy, 106 is not applicable. And there's a Supreme Court judgment. No?
Yes.
What is that? 70?
Under the Planali Amal, the decision of here. It is in respect to Madras High Court judgment regarding protection of tenants act.
Is there a constitution bench judgment? It was that constitution bench judgment in 1977 or what is that?
Here it is case that if tenancy is denied, then no question of protection.
He's denied the tenancy.
Yes. And my food has been in all the food has been decided in my favor, except with the notice.
No, why I'm therefore looking into, you see, they have admitted the cross objection. First of all, this cross objection, if it is done, can be a cross objection against the counterclaim. They cannot be.
The degree is
Now, these substantial questions of law which have been formulated, mentioned out there, whether the compromise decree dated so and so is legal and valid. Let us see your claim, your written statement. Either claim. Where is the original plaintiff? Or else.
Page 62.
Trial court judgment. 8
I'll put the
in typed out.
Page 10.
Page 54. The trial court judgment.
Yes, ma'am. Page 10, ma'am.
page
Of
Of my lord, appeal filed by the.
your case it is 55.
Yes.
Who is the plaintiff? And that is why I'm not finding very difficult.
Lokhipriya.
Then why is it written? Kindly see page 55 of the court. The plaintiff brother Madhav Chandra Kolita was the owner of the land.
Madhav Chandra Kolita originally
Was the owner of the land, measuring 1 bigha 2 katha 10 letters covered by PP Patra number 20. It is contended that the plaintiff, kindly see this, plaintiff had filed a civil suit against Lokhipriya Kolita. Now, who is Lokhipriya Kolita?
Lokhipriya Kolita is the plaintiff in this suit. And the earlier
And who is the plaintiff?
Madhav Chandra Kolita was the plaintiff against Lokhipriya Kolita in another suit. So he has been referred as plaintiff. And in that case, my lord,
In fact, the main problem arose because you have stated in paragraph 3 of your plaint in that matter. So wrongly you have described it anyway. The plaintiff had filed a suit. Who is the plaintiff brother? Who is the plaintiff? Plaintiff brother Madhav Chandra Kolita is Lokhipriya Kolita. Brother is Madhav Kolita.
There was a compromise between them and the suit was agreed on.
Then what happened? What was the compromise?
Then my lord, the Lokhipriya Kolita became the owner of the land.
How much?
As per the compromise.
How much?
1 katha 10 letters. Yes.
Was relinquished by the defendants. How do you bring again the defendant? What type of pleadings are these? In absolutely therefore very difficult to understand. So you became the owner of 1 katha 10 letters. And remaining 1 bigha 1 katha was divided equally between the plaintiff and the defendant. Meaning?
Rest of the land. There were 4 kathas after the sale of the land.
So we dismissed the entire appeal as well as this objection, everything because of a wrong. The plaint, the edifice of the plaintiff. Better go to Supreme Court and explain how is it. No, Mr. Chaudhary, I'm dismissing both. It is a wrong, absolutely incorrect description in the plaint. And when the plaint is the entire thing is wrong, so nothing remains. Let me dismiss. No, sorry. We are dismissing.
All issues.
No. We are dismissing. We are dismissing this.
Concurrent finding in respect of.
Forget about the concurrent finding. We are dismissing it on that ground. That question of law will arise only on fact. The plaint is wrong.
Plaint is not wrong, my lord.
Absolutely wrong. Kindly read page 6 of your plaint. Let us see your plaint. Show me. Tell me, explain to me how the plaint is right. Read the plaint. Yes, read it. Page 64. Yes.
That a plot of land measuring 1 bigha 10 letters covered by periodic under Purang Muda, district of Purang was setting the name of the Madhav Kolita, son of the Huriram, the brother. Thank you.
that in 1987 the plaintiff had filed a civil suit at Mongoldoy Court against him to Lokya and seven
No, 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 wait. That in 1987, the plaintiff filed a civil suit. Who is the plaintiff? The plaintiff had filed. Earlier, you were saying the brother of the plaintiff. The plaintiff had filed a suit against Lokhopriya Kolita. Now, Lokhopriya Kolita happens to be the plaintiff.
No, my lord. I'm sorry, my lord. Plaintiff is Lokhipriya Kolita. In that
Okay,
suit,
so
my lord,
you filed a suit against yourself.
no, Madhav Chandra Kolita.
Kindly see here. In 1987, the plaintiff had filed a civil suit against Lokhipriya Kolita and 7 others. And in respect to the said plot of land property, the civil suit was registered in a year. The said suit later on transferred to Udalguri Municipal Court and renumbered as so and so. That in the said suit, now can you see, was disposed of on compromise on so and so, and as per the terms of the compromise reached between the parties in the said title suit number so and so, the right title and interest over one katha of land which is shown in Schedule B out of 1 year of the land was relinquished by the defendants.
In favor of
Defendants, they have relinquished it in favor of the plaintiff. In favor of the plaintiff. Plaintiff means Lokhopriya.
Lokhipriya.
The defendants. So did the defendant, where these defendants are party to the suit?
Then Madhav Kolita.
What?
Madhav. Well, in between Madhav Kolita and Lokhipriya Kolita,
No, this is wrongly done.
the
The
plaintiff.
entry ID and any evidence given which is divorce the pleading is wrong.
Well, the evidence.
No, we can't look into the evidence. Any evidence contrary to the pleadings is wrong. So we dismiss both the suit and your cross objection. You want the cross objection allowed? Let us see whether in your written statement you have correctly given. It's a high time. Pleading can't be in this manner.
Well, in the
No.
in paragraph 3, Madhav, the last line.
Everything is wrong.
It is worth to mention here that in the year 90, the plaintiff of the present suit was also plaintiff. The remaining 1 bigha and 1 kotha of land was equally divided between the plaintiff and the defendants. As per the compromise reached between the parties in TS 90, the plaintiff there falls 4 kotha 10 lessers of land out of 1 bigha 2 kotha 10 lessers of land, which is shown in the Schedule A. And accordingly, on 12/10/93, the Schedule A land mutated in the name of the plaintiff. That the land shown in the Schedule B is a part of the Schedule A land. There is standing a long Assam type dwelling house having several rooms over the Schedule A land, which is also covered the Schedule B land. Now the part of the house standing over the Schedule B land is the house of the clear, my lord?
Not clear.
My lord, the Schedule A land.
You
is
better explain all these things before the Supreme. Let the Supreme Court understand. I
Schedule,
am not convinced.
Schedule A land is the land, my lord.
No.
And Schedule B is
No.
joint property, my lord. Along with that, my lord, the Schedule A house is also situated in the case. And all the issues have been decided in my favor, except the issues regarding notice. Notice was improper. That is why it was dismissed and cited because of not having possession.
Where have you mentioned that the defendant have denied your title in your claim?
In plain, my lord, I have agreed, my lord, that
How do you apply the judgment?
he was a tenant. He was
How do you apply the
according to,
judgment?
according to me, he was a tenant. And he denied in written statement that he is not tenant.
So,
He was not
so
tenant.
post filing of the written statement, your case becomes better.
My lord,
Post filing of the written statement, does your case become better?
my lord, he denied himself as tenant. So how he can claim notice of, my lord? If he, according to him, there is no tenancy, then no question of notice also, my lord, in the for notice, it cannot be dismissed, my lord. Suit cannot be dismissed. If the deer had only 111C of the Transfer of Property Act, is that forfeiture of
Where is it mentioned that the Schedule C building is situated on Schedule B land?
in paragraph 5, that the defendant number was a tenant under the Madhasundra Kodita, a brother of the plaintiff, in respect of the part house of standing on the Schedule B land, which is described in the Schedule C. He took out the house on rent, agreeing to pay monthly rent during the first week of every following English calendar month, and to vacate the two houses as he required the brother of the plaintiff for own use and occupation. But in the written statement and counterclaim, he has claimed.
Let us not go into the written statement and counterclaim. First, let us go into your fact.
Yes.
Let us see your fact. What are those?
That since 7/12/1992, the date of disposal of ES2 of 90, the plaintiff became the owner of the scheduled land and the house standing thereon. The defendant number 1 agreed to pay the monthly rent of houses since January 1993 at the death of that month. Also agreed to vacate the house whenever it will be required by the plaintiff for own and occupation. Since 1/1/93, the defendant number 1 becomes a tenant under the plaintiff in respect of the house. So the plaintiff is a retired tea garden employee. The plaintiff has 3 sons and 2 daughters, besides his wife, who are living with him at Mohilapara place. Now it becomes inconvenient on the part of the plaintiff to live at the house situated at Mohilapara due to increasing in his family members. Therefore, he approached the defendant number 1 several times and requested to vacate his house that he required the same for his bona fide use and occupation. But in spite of repeated requests made to defendant number 1, he did not vacate the same. Thereafter, the plaintiff on 12/6/95 sent a notice raised by registered post the defendant number 1 vacate house by removing all its belongings from the house, failing which it was stated in the state notice that suit for ejection be filed against him for removal from the good house. By that notice, the defendant number 1 also asked to pay plaintiff the arrears of houses for the period commencing from the month of January 1993 to May 1995. The defendants are running stationary grocery shops on the veranda of the suit house and one living in the same suit house. The defendant number 1 has not delivered possession of described in the CCTV of the plaintiff in spite of repeated demands made by the plaintiff. It has already been stated earlier that the plaintiff requires the house for his bona fide immediately. The defendant number 1 has not paid to the plaintiff the monthly rent from 1/1/93 till today. The defendant number 1, not having paid the rent as per agreement, has become a defaulter. Defendant number 1 is not liable for rejectment house on the ground of bona fide, on the ground that the defendant number 1 is a defaulter. Hence, the plaintiff has compelled to file this suit against the declaration that the plaintiff has right title interest over the and he has legal right of the standing over the and for dependence from the house standing over the and for recovery of areas of outside for permanent suit is valued at 5,800 for the purpose of jurisdiction and court fee being paid here. This court fee is paid for and court fee is being paid. It 5,800 being the house and for 7 months of 31,555.
Now, what is this paragraph number 8? of your plaint, is it true?
Hereafter the plaintiff. This is regarding notice. Or determination of debt. And subject
Then what is 106? A notice under subsection shall not be deemed to be invalidly made because
it has come my lord, in 2003. My lord.
which one? Huh?
Subsection 2 that has come my lord, after 2003 amendment. Before that, my lord, it was there. That is why my lord, the issue of notice that has been decided.
When was the notice issued? 95. So prior to that, 106 said, in absence of a contract to the owner, a lease of a immovable property for agriculture or manufacturing shall be deemed to a lease from year to year, terminable on the part of either the lessor or lessee by 6 months notice,
15 days.
expiring with the end of the year of the lease of immovable, if any other shall be deemed to be a lease of month to month, terminable on the part of the other by giving 15 days notice, expiring with the end of the month the tenant. So you require 15 days notice.
15 days notice was there, but it has been decided wrongly that the notice was improper. That is, so suit cannot survive. That is the finding of the
No, if it is the suit is for a house,
yes.
then how do you say that it is not a suit for a lease for immovable property?
Month-to-month tenancy, my lord, that
Why it won't be for month to month?
yes.
In absence of a contract or law or uses to the contrary, a lease of an immovable property for agriculture. This is admittedly not for agriculture or manufacturing purpose. This is also not for manufacturing. Shall be deemed to be a lease from year to year, terminable on the part either by the lessor or lessee, by giving 6 months notice expiry in the end of the tenancy. And a lease of a immovable property for any other purpose shall be deemed to be a lease from month to month, terminable on the part of either lessor or lessee by 15 days notice, expiring with the end of the month of tenancy. Every notice under this section must be in writing, signed by or on behalf of the person giving it, and either by sent by post to the first party who is intended to be bound by it, or be tendered to an. So here in paragraph number 8, you say that their notice was issued asking him to vacate. I don't understand again. Thereafter, the plaintiff on 12/6, read paragraph 8.
Hereafter, the plaintiff on 12/6/95 sent a notice to registered post petition number to vacate the suit house by removing all his belongings from the suit house.
How can it be prior?
Maybe typing error.
What typing error? So much a mistake. If I allow this appeal also, I will impose cost on the appellant. The pain and agony this court has to go because of this type of pleading should be given to, cost should be imposed, should be given to the legal services authority. And taking your stature, being earlier the president, we start the bidding at 50,000, the cost. Start.
I am not.
And further difficulties which will arise will be another. The cost will be upon you, don't worry. Not on the appellant. On Mr. D.C. Chaudhary. Yes. Goodness.
But in written statement, they have denied complete payment. And about denied that they was a tenant under either under part of paragraph 11 that is 74 of the written.
Mr. Islam, you are saying on one hand in your counterclaim that you are the owner. You were you taken the land in 1940 from some Chittaranjan Chakraborty of Jordan. And thereupon you have been possessing. Okay?
Yes.
So your right to adverse possession accrues from when?
My lord, page 78, my lord. It start from page 77.
Kindly come to 86.
My lord.
86. Cause of action arose on 12/6/1995. Date of the notice on 8/8/1995. So where is the question of your cause of action arising from 1940?
Because my lord, I have stated in my counterclaim, my lord, that I am possessing the land, my lord, from 1940, my lord.
But 40 understood. Adverse possession requires the three elements. It has to open, hostile, and notorious. What act did you do?
My lord, I have
Did you get your name mutated?
my lord, in page 77, my lord.
First of all, you are saying that this land is not a part of, in some portions of it, is not a part of the one katha 2 letters, 10 letters of land which the plaintiff got. So therefore, you are not admitting that the plaintiff is the owner
Yes.
of the land, or not admitting. Now, you are saying which portion of the land, in whose land you are claiming adverse possession.
My lord, I have stated, my lord, in
Kindly come to here.
page 70.
No. Kindly see this particular. Paragraph number 30, page 83. That the present
The
defendant
present
number 1
number 1
and Gopal
and
Poddar
Gopal
were in
Poddar
possession
were
of the
in
land
possession
within
of
the
the
boundary described in TS 2
two
of the Iman, filed by the present plaintiff, Hogan Kolita. But in the said suit, they were not made a party. So therefore, you say that you come within the ambit of that 1 bigha 2 kathas. Okay. That the present suit has not fallen in the share of the land plaintiff. So therefore, you are not claiming adverse possession against the plaintiff. Isn't? If we understand the concept of adverse possession, the adverse possession has to be an adversely to the interest of the true owner. So the moment it is found out that the land has fallen in the share of the plaintiff, your plea of adverse possession falls like a pack of cards.
Yes.
How do you take care of that?
Present suit then has not fallen in the share of the plaintiff. It is not within the boundary of the land in the share of the plaintiff, Hogan Kulcha, in TS number 2 of 19. And the present suit land is on the extreme south where land of Gopal Poddar is bounded by the share of the Madhav Chandra Korita dependent on the north and present suit land on the south.
So under such circumstances, you say that you have adverse possession against Madhav Kulta. But Madhav Kulta is not a party.
Yes.
So your counterclaim by seeking adverse possession has to be against the true owner.
Yes.
So without that, your plea of adverse possession falls. If this is the thing to be accepted, then you kindly see again, 32. The share of the land of Hogan Kulta, plaintiff in title number 2, is towards north of Gopal Poddar, having the land of Madhav Chandra Kolita, defendant in title suit in the midst of Hogan Kolita and Gopal Poddar. And present suit land is on the south of Gopal Poddar, distinctly quite away from the share of Hogan Kolita. And as such, the claim of the plaintiff to have acquired right title and interest and possession over a suit land by the diet of compromise is quite baseless and false. So you don't accept that the plaintiff is the owner on the basis of the compromise. The moment it is not there, so under such circumstances, again, adverse possession cannot be again. You may it may be you may have a right of occupancy against any other trespasser. That's another aspect of the matter. But the question of adverse possession could not have been gone into if this is your state. Then, if you are claiming your adverse possession, the adverse possession has to be, because the Supreme Court categorically says that it is taking away a right of a person, of an owner. So if it is taking away the right of the owner, your burden lies upon it when you pay heavy. Meaning thereby, you are stating your pleadings on which date you have asked this person, from what date you have been taking over this land, how did you enter, what overact act you have taken. Where is it? You say that Chittaranjan Chaudhary or this person, Chittaranjan Chaudhary, had allowed you to stay. Vacant land. Then it may be allowed you to stay would come within the ambit of a permissive occupier. Where is that? And where are you saying? You are also saying in some manner that that land originally belongs to Chittaranjan Chaudhary. You see?
Yes.
Have you given it proof? Let us see your evidence. Did you file written statement against the counterclaim? On the basis of these, whether cause of action, whether suit is bad for non-jointer, proper court fee, is bad by limitation, is profit of it is relevant. The place to be
Then objection was filed.
Welcome back. But
Yes, yes.
I don't like keep TV.
Can I take a chance on next this Friday, man? Or on,
You see, I'm only the person taking a bench for.
okay, okay.
We'll have the next Tuesday,
Well, Tuesday I'm already so many matters are fixed. Let it be on Thursday.
21st.
Ah.
21st. It's the matter.
Well, 21st I'm not there. I'm going to Shillong for
28,
28. No, let it be, can it be 20, my lord? 20,
20,
20.
20 is Wednesday.
Oh, oh, oh.
Wednesday will
28
be-
also I'm having difficulty. My lord.
28 difficult.
That's why I was thinking it could be next Thursday, madam. I'll take a chance if it is possible.
It is on 14.
Okay.
It's the matter. Because
Deeply.
What is exhibit core? Islam. And what is exhibit 4?
Or is that
Exhibit 4 is the deed of sale dated 16/12/63, which Gopal Poddar purchased from Madhav Kulta. How is exhibit 4 relevant?
the purchase deed?
Huh?
Deed number 3611.
Not understood. How is also exhibit 4 relevant for you? Are you saying that you are the tenant of Gopal Poddar?
Yes, Gopal. Gopal Poddar.
Where? Have you stated that you are the tenant of Gopal Poddar? Because that is completely contrary. Because you are asking for adverse possession. How is it possible? Exhibit 4 is a sale deed.
Tell it.
Now, exhibit 4, he says that he had purchased land. But exhibit 4. how could the decree be satisfied without there being boundaries to Schedule B? The plain does not contain boundaries. Page 70. You are claiming right title interest about Schedule B.
It will be, my lord, that
Where is the boundary?
periodic factor and measuring cost that out. That is after it,
Then
tag number 480 and it created on the top that Purang Moda. It would see description of the it, room measuring 28 feet to 14 like house. Yeah,
no. Here, look. This will come covered by
yeah, there
bounded in the north by Gopal Potter's land, south by J. Shankar.
it would be a
Gopal Potter's land is that land of 1 bigha, 1 katha, 4.5 letter. That is exhibit 4 land. South by Jainath Deka.
okay. Right. So, it is told.
Mr. Plum, you did not file an appeal against the counterclaim.
Yes.
Well, you did not file an appeal. Did you or not?
No, my lord, against the dismissal of the
Counterclaim, did you
counter-
file an appeal?
no, no appeal was.
Then, so the counterclaim in rests. It was a suit, it was a decree. So the decree, as regards the counterclaim rests. Now, how only that question of law which has been framed
Regarding
would entitle this court or empower this court for setting aside the decree passed by the first appellate court, taking into account that you have not been able to prove that he was your tenant, where the first appellate court held that you could not prove it.
substantive question of law,
Only one.
I submit
You submitted, that's a different thing. I can't frame it now. There's only one substantial question of law on 106, nothing more than that.
on
Yeah.
regarding notice. Notice, my lord, if it was for different notice. Notice was not proper, that is why notice not taken. But here in this case, no notice is required. If tenancy is, my lord, that is denied by the defendant. What is the question of notice? That is the only question. If it is said that notice is not required, then my lord, should come in my favor
entire findings of the court, my lord, issue the.
How do you take care of the decision in issue number in the appellate court judgment
Yes.
as regards
To number
Case
10,
47, my lord, appellate court judgment, my lord, wherein, my lord, it was held that, my lord, defendant is not a tenant.
my lord, issue number 10 is the issue regarding right title interest.
Hmm.
Whether the plaintiff has acquired right title interest over the suit land and has got possession over it.
now here the court had also set aside the mutation also.
Appellate court. Not the
We are not concerned that the judgment of the trial court has already merged.
appellate court mutation, my lord, if your lordship, you kindly go through the
Paragraph
issue-
18,
issue number 10, my lord.
issue number 11, para 18. You also could not prove that he was a tenant of
Tenancy,
Madhav Kolta also.
my lord, he has totally denied his tenancy, my lord. And even adverse position has been claimed. In adverse position, he has stated that in his evidence also he has stated whether the land is government land or is owned by some other person, he doesn't know. This is his statement. And my place is clear, my lord, that I got it from Madhav Gupta. I got it from Madhav Gupta, and the boundary given in the earlier compromise between that was the land which was on the basis of which right title interest has come. So, my lord, that is finding that I have got the right title interest of the court. But appellate court's judgment is that since I have no position at present, that is why that cannot be decided in my favor. So after finding, my lord, in respect to the 11, number 11, issue number 10. I am reading, my lord, the case 50. Okay. Whether the plaintiff has acquired legal right title over land and has got possession over it as per compromise in title number 4, 1990. Evidence of PW 1, plaintiff. The Fogendro Colita is that the suit house was earlier rented to Sri Sitaram Nagiram Agorala by Sri Madhav Colita, brother of the plaintiff. He left the rented house when he failed to pay the house tax. He has further stated that as per compromise made in title suit number 2 of 90, the suit land and the house fell in his there, and exhibit 9 is the copy of the compromise section 5 in title suit number 2 of 90. Exhibit 11 is the copy of final order passed in above suit passed by the landed munshi, Dalkudi. And exhibit 13 is the record of PS 90. Exhibit 41 to 49 security revenue paying receipt in the name of the plaintiff, Bhavendra Kolita and his deceased brother Madhav Kolita. The evidence of PW 43 Dilip Kolita, who is the son of late Madhav Kolita, deposed that as per the compromise, the suit land falls under the share of the plaintiff. PW 15 Lohit Nath Latmandal Mazbat Sarpur deposed that by order dated 12/10/1993, land measuring 4 kotha 10 acres were mutated in the name of the plaintiff Bhagendranath Kolita along with father late Madhav Chandra Kolita. Exhibit 9 and 11.
Okay,
also,
show me that judgment. The Supreme Court judgment. heard Mr. Dikto explain it very on top of that. And Mr. Dikto explain it on the This is an appeal and section 100 but not the court. Assailing the judgment and decree dated 26/9/2003, passed by the learned judgment and decree dated 30/4/2009, passed by the learned civil judge Dorong Mongoldot, entitled Appeal number 28/2003, arising out of Appeal number 28/2003, whereby the judgment and decree dated 26/9/2003, passed by the learned civil judge, Junior Division Udalguri, entitled suit number 15/1995, was affirmed. This court, by an order dated 4/6/2010, had admitted the instant appeal by formulating the following substantial question of law. Whether, in view of the denial of tenancy by the defendant, the notice under section 106 of the Transfer of Property Act is required to be issued by the plaintiff before institution of the suit for declaration of right, title and interest and recovery of khas possession. This court has also taken note of that a cross objection has been filed by the it has been numbered as cross objection 6/2011. In the backdrop of the above, let this court therefore take as to whether the substantial question of law so formulated by this court is involved in the instant appeal. The fact which could be ascertained from the pleadings, more particularly plain, reveals that one Kogen Kolita, who was the original plaintiff, had instituted a suit being titled suit number 15/1995. As per the plaint, the said Kogen Kolita, as per the plaint, a plot of land measuring 1 bigha, 2 katha, 10 lecha, covered by tag number 27, tag number 163, and included in periodic patta number 27 of Masbat town under Orang Moda in the district of Dorong, Assam, stood in the name of one Madhav Chandra Kolita, who was the son of late Abhiram Kolita. The original plaintiff was the brother of the said Madhav Chandra Kolita. On account of certain differences, a suit was filed by the original plaintiff against the said Madhav Kolita and 7 others in respect to the said property measuring 1 bigha, 2 katha, 10 lechas. The said suit was registered and numbered as title suit number 13/1987. Subsequent, the said suit was transferred to the Udalguri Municipal Court and renumbered as title suit number 2/1990. The said title suit being title suit number 2/2019-90, was disposed of on compromise by an order dated 7/12/1992. In terms with the compromise, out of the land measuring 1 bigha 2 katha 10 lecha, a plot of land measuring 1 katha 10 lecha fell into the share of was given to the original plaintiff, and the remaining land of 1 bigha 1 katha was shared between the original plaintiff and the said Madhav Kolita. It is the further case of the plaintiff that in terms of the said compromise, a plot of land, a total plot of land measuring 4 katha 10 lecha out of 1 bigha 2 katha 10 lecha fell into the share of the original plaintiff. And this particular plot of land have been more specifically described in Schedule A to the plaintiff. Out of the said Schedule A plan, in the said Schedule A land, the said Schedule A land included the plot of land measuring 1 katha 10 lecha, which have been more specifically described in Schedule B to the plaintiff. It is the further case of the original plaintiff that the defendant number 1 was the tenant under the said Madhav Chandra Kolita. And thereupon, after the compromise decree passed in title suit number 2/1990, the said defendant number 1, the house wherein the defendant number 1 was residing fell into the share of the original plaintiff, taking into account that the said house stood on the Schedule B land. It has been also mentioned that after the land and the land described in Schedule B and the house standing thereon fell into the share of the original plaintiff, the defendant number 1 agreed to pay the monthly rent of the suit house to the plaintiff since January 1993 at the rate of rupees 200 per month. However, the defendant did not pay any rent with effect from 1/1/1993 as promised. Under such circumstances, on 12/6/1995, a notice was issued to the defendant number 1 to vacate the suit house by removing all his belongings from the suit house by 15/7/1995, failing which it was mentioned that the suit for ejectment would be filed against the defendant for eviction from the suit house. On the ground of default in payment of rent, as well as also on the ground of bona fide requirement, the suit was filed seeking declaration or seeking inter alia, the declaration of right, title, and interest of the plaintiff over the Schedule B land, for ejectment of the defendant from the Schedule C land and delivery of cash possession, semicolon, decree for arrear of rent amounting to rupees 5,800 and for permanent injunction. Pursuant to the filing of the said suit, which was registered and numbered as statute number 15/1995, the defendant appeared and filed a written statement along with a counterclaim. In the said written statement, the defendant categorically denied that the defendant was a tenant of the plaintiff. Further to that, it was mentioned that the said compromise decree in title suit number 2/2020 shall not be binding upon the defendant, taking into account that the said defendant was not a party to the said proceedings. In addition to that, various pleas were taken as regards the maintainability of the suit, including the plea at paragraph number 24, that the plaintiff had not complied with the provisions of section 106 of the Transfer of Property Act 1882, for short, the Act of 1982. Record close. While serving notice, and as such, the said notice which was issued was invalid. Be that as it may, it is relevant to take note of that at paragraph number 14 of the plaintiff, a written statement, it was duly admitted that the plaintiff's notice was duly received by the defendant number 1, but the said notice was contrary to the provisions of section 106 of the Act of 1982. Further to that, it was also stated that the Masbat town, being not a notified town, but a revenue town, for which the provisions of the Assam Urban Area Rent Control Act 1972, for short, the Act of 1972, is not applicable. In addition to the above, in addition to the written pleadings in the written statement, the plaintiff had also filed a counterclaim. In the said counterclaim, it was the specific of the plaintiff and defendant also filed a counterclaim. In the said counterclaim, it was the specific case of the defendant that since 1940, the defendant number 1 had occupied the suit land, measuring 1 katha 10 lechas of land, and constructed a thatched house thereon and started a tea stall business. It was mentioned that at that point of time, one Chitta Ranjan Chaudhary was the owner of the land, but neither he nor his heirs nor any person ever objected to the possession and the construction of the house thereon and the running of the business by the defendant till filing of the suit by the plaintiff. It was further mentioned that the thatched house standing and constructed by the defendant number 1 was demolished and removed in the year 1963, and the houses described in the schedule to the suit were constructed by the defendant number 1 and thereupon continued the tea stall. It was further mentioned that some of the houses were, it was further mentioned that the defendant stopped the tea stall and let out to different tenants on monthly rent. In the year, in or about 1987, the defendant number 1 again started carrying on the tea stall business, and in the year 1988, the said tea stall business was converted into a grocery shop and it being continued till the date of filing of the written statement come counterclaim. It was also mentioned that though Madhav Chandra Kolita had purchased the said land from Chitta Ranjan Chaudhary, he could never take possession of 1 kata 10 lechas of land from the standing possession of the defendant number 1. Is it mentioned in the plain that you purchased from Madhav Kolita, purchased from here? I don't see it anywhere. Huh?
In the compromise document, he got it.
There is a mention that you purchased from Chitta Ranjan Chaudhary.
Madhav Kolita purchased it from Citron, so it is in the immediate. Not in the plain.
No, it is not there in the plain. Further to that, it has also been mentioned that the defendant number 1 have been possessing the said land by constructing houses in the schedule to the plain exclusively, openly, and uninterruptedly as his own and adversely against the interest of the true owner for more than the statutory period of 12 years, and whatever right, title, and interest the owner, including the plaintiff, had, if any, was extinguished, and the same had vested upon the defendant number 1. This court further finds it relevant to take note of that at paragraph number 31 of the said written statement cum counterclaim, it was categorically mentioned by the defendant that the suit land had not fallen into the share of the plaintiff. It was stated that it is not within the boundary of the land in the share of the plaintiff, plaintiff. And the present suit land is on the extreme south, where the land of Gopal Powder is bounded by the share of Madhav Kolita on the north and the present suit land on the south. On the basis of the said pleading and the counterclaim, the defendant filed a suit seeking a declaratory decree that the lawful owner due to their adverse possession by the defendant have lost their right and title, and the defendant had acquired the right of ownership by adverse possession over the suit land. In addition to that, the defendant also sought for a declaratory decree that the mutation passed on the suit land in the name of the plaintiff is not proper and illegal and liable to be cancelled. Further to that, the defendant also sought the relief for issuance of a precept to the circle officer of Masbat Revenue Circle for cancellation of the mutation recorded in the name of the plaintiff in the suit land and to record mutation in the name of the defendant number 1 to 7 in the suit land. On the basis of the said pleadings, the plaintiff thereupon filed its written statement to the counterclaim filed by the defendant. On the basis of the pleadings, as many as 14 issues were framed by the learned trial court. The defendant, the plaintiff, have adduced the evidence of 5 witnesses and exhibited various documents from Exhibit 1 to Exhibit 18. The defendant side adduced the evidence of 3 witnesses and exhibited various documents from Exhibit 4 to Exhibit Shaw. CH. The learned trial court, by judgment and decree, dated 26/9/2003, dismissed the suit. This court, however, finds it very pertinent to observe that while dismissing the suit, the learned trial court came to a categorical finding that on the basis of the compromise decree passed in title suit number 2/1990, the land in Schedule B fell into the share of the plaintiff. The learned trial court also had come to a finding that the defendant failed to prove his right, prove his claim of adverse possession. The learned trial court came to a finding that the defendant could not, that the plaintiff could not establish that the plaintiff had possession over the suit land pursuant to the compromise decree passed in title suit number 7 and 9, isn't it? Title suit number 2/1990. The learned trial court also came to a finding that the suit land, that the dispute in respect to the property did not fall within the ambit of the Assam Urban Area Rent Control Act 1972, taking into account that the Masbat town was only a revenue town and not a notified town. However, while deciding the question of notice under Section 106 of the Act of 1982, which was issue number 1, issue number 2, the learned trial court came to a categorical finding that the said notice was not in accordance with the provisions of Section 106 of the Act of 1882, taking into account that as per Section 106 of the said Act, the notice should have mentioned that the tenancy would expire on 30 or 31st of every month, But as per the notice which was issued, the defendant was asked to vacate by 15th of July 1995, which is not that, which in no case can be the date of expiry of the tenancy. On the basis of the said opinion, say decision in respect to issue number 2, the issue number 1 was decided that the suit was not maintainable, and consequently the suit was dismissed. Being aggrieved, the plaintiff preferred an appeal. The suit was dismissed. In addition to that, the learned trial court also dismissed the counterclaim. It is well settled proposition of law that a counterclaim is also a suit, and as such, the decree passed in the suit is a suit, and as such, dismissal of the counterclaim would also come within the ambit of a decree. Be it as it may, the plaintiff filed an appeal before the learned First Appellate Court, that is the Court of the Civil Judge Dorong at Mongoldoy, which was registered and numbered as title appeal number 28/2003. However, the defendant did not file any appeal against the dismissal of the counterclaim. Under such circumstances, the dismissal of the counterclaim had attained finality. Next. The learned First Appellate Court dismissed the said appeal by the impugned judgment and decree dated 30/4/2009. In coming to that opinion, while deciding the said appeal, the learned First Appellate Court, while affirmed the findings of the learned trial court on the question that the plaintiff had acquired right, title, and interest over the Schedule B property on the basis of the compromise decree dated so and so passed in title suit number 2/1990. The learned First Appellate Court further opined that also affirmed that the plaintiff had no possession over the said Schedule B land pursuant to the compromise decree dated so and so in title suit number 2/1990. Be that as it may, the learned trial court, irrespective of the counterclaim of the plaintiff having been defendant having been dismissed, reversed the finding in issue number 11 as regards the mutation. Issue number 11, na? As regards the mutation made in favor of the defendant, in favor of the plaintiff, which in the opinion of the court could not have been done in view of the dismissal of the counterclaim and there being no appeal filed there against. Be it as it may, the learned First Appellate Court again affirmed the decision and as regards the non-maintainability of the suit under section 106 of the Act of 1882 for the same reason as was observed by the learned trial court. Consequently, the learned first appellate court also held that there was no cause of action for the suit, and therefore the appeal was rightly dismissed. Therefore, the appeal and therefore the appeal was therefore the appeal was dismissed. In the backdrop of the above, let this court now take up the cross objection which have been filed by the learned first appellate, by the defendant in the proceed. In the same cross objection, the defendant proposed 4 substantial questions of law. The said cross objection, though having been admitted, but there's no substantial questions of law were formally under such circumstances. This court takes up the said cross objection within the ambit of Order 41, Rule 11 of the court, and to decide as to whether the said substantial questions of law which have been proposed in the cross objection arises. The substantial question of law to propose can be formulated. This court is of further opinion that the said requires to be done at the foremost taking into account that in the circumstance, any substantial question of law is formulated, then in that case, the decision of the accompanying second appeal has to be deferred. This court have duly taken note of the 4 substantial questions of law which were posed. The first substantial question of law was whether the compromise decree dated 7/12/1992 is legal and valid. In the opinion of this court, that the said compromise decree dated 7/12/1992 was never put in question during the trial, and as such, the same cannot be formulated as a substantial question of law involved in the instant appeal. The second substantial question of law proposed is as to whether the suit for declaration of title in respect to the suit land is barred by the proviso to Section 34 of the Specific Relief Act 1963. This court finds it relevant to take note of that Section 34 of the Specific Relief Act 1963 stipulates as to when the court is required to pass a declaration. The proviso to Section 34 stipulates that no relief, no declaration should be granted unless the plaintiff have sought for the further relief. Further relief, what is the term used? The proviso to Section 34. Unless the plaintiff seeks for further relief.
Any person entitled to any character or to any
No. See the proviso.
provided that no court shall make any such declaration. where the plaintiff being able to seek further relief, then a mere declaration of title needs to do so.
The proviso to section 34 categorically mandate that the court should not grant a mere declaration, or should not grant a declaration where the plaintiff who is capable enough, now what is the word used?
Provide,
Okay, get up on it.
no court shall make any such declaration where the plaintiff.
Give me the book, give me the book.
is-
Will be much easier. Proviso. The proviso to section 34 makes it clear that no court shall make such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. In the instant case, this court have duly perused the written statement. Such a plea was never raised in the suit in the written statement. Under such circumstances, the said plea could not have been raised for the first time before in the second appellate court. Apart from that, this court have also duly perused the plaint in title suit number 15/1995. 15, na? 15/19, huh? Huh? No. 15, na? 15 of 1995. And from a perusal thereof, it is seen that the plaintiff not only asks for declaration of right, title, and interest in respect to the property to plan, more specifically described in Schedule B to the claim, but had also sought for recovery of possession, and permanent injunction. The claim for recovery of possession and permanent injunction are consequent are further reliefs which the plaintiff was being capable enough have duly pleaded, have duly sought for. Under such circumstances, the proviso to section 34 of the Specific Relief Act does not come into play, for which the second substantial question of law so proposed does not arise in the instant appeal. The third substantial question of law so proposed is as to whether the judgments of both the court below are vitiated by non-consideration of the admission and exhibit 4. This court have duly taken note of that the fifth substantial question of law so proposed is completely vague, inasmuch as a perusal of both the judgments of the first appellate court as well as the learned trial court, it is seen that exhibit 4 have been duly taken into consideration. This court further finds it relevant to take note of that in the pleadings of the defendant, both in the written statement as well as in the counterclaim, there is no mention about a purchase made by, what is that person's name? Gopal Poddar. By the said Gopal Poddar, by the deed of sale dated, this is dated 21. Dated 16/12/1963, which is exhibit 4. Under such circumstances, the said exhibit 4, under such circumstances, the said question of law so proposed in the opinion of this court does not come within the cannot be said to be a substantial question of law involved in the instant appeal. The fourth substantial question of law so proposed is as to whether the courts below were right in holding that the defendants did not acquire title by adverse possession. The counterclaim having already been dismissed by the judgment and decree passed by the learned trial court, and there being no appeal filed thereagainst, the said dismissal of the counterclaim had already attained finality. Apart from that, this court have duly taken note of the evidence of DW1, who was the defendant number 1, who categorically stated that he did not know who was the owner of the land wherein he was in upon which he was in possession. It being a trite principle of law that adverse possession has to be adverse to the true owner, and the plaintiff defendant having not known in his evidence categorically stating that he does not know who was the owner of the land in question, makes it clear that the plea of adverse possession on the face of it was totally misconceived. Under such circumstances, the fourth substantial question of law so formulated does not arise. Now moving forward, this court finds it relevant now to take into account as to whether the substantial question of law framed by this court in its order dated 4/6/2010 can be said to be a substantial question of law involved in the instant appeal. This court have duly taken note of Section 106 of the Act of 1882, which categorically states that it is the requirement of issuance of notice that there is a requirement of issuance of a notice. This court have duly taken note of the provisions of Section 106 of the transfer of the Act of 1882 as it stood prior to 31/12/2002. In terms with the said section, it is clear that where a lease of an immovable property, where stipulate that in respect to a lease of an immovable property for any other purpose, that state lease shall be deemed to be a lease from month to month, terminable on the part of either the lessor or lessee by 15 days notice expiring with the end of the month of the tenancy. The question therefore arises as to whether the said provision can be made applicable and the plaintiff be non-suited on the ground of Section 106 in a case where the defendant have categorically denied the tenancy of the landlord-tenant relationship between the plaintiff and the defendant, and also have claimed adverse possession. This court had duly also taken note of that the learned First Appellate Court had categorically come to a finding that the defendant was not a tenant of the plaintiff or even Madhav Chandra Kolita. Under such circumstances, the learned First Appellate Court ought to have considered as to whether Section 106 of the Act of 1882 as it stood prior to 31/12/2002 could have at all be applied to the facts of the case. So this clearly shows the total non-application of mind of the learned trial court as well as the appellate court in passing the impugned judgments, thereby dismissing the suit on the ground of section 106 of the Act of 1882. This court have also taken note of that it was on account of this issue number 2 which was decided. All other important issues have taken a backseat, and the issue number and the preliminary issues as regards cause of action and non-maintainability of the suit had taken the forefront. Taking into account that the issue number 2 was wrongly decided by the learned trial court as well as the first appellate court, thereby applying section 106 of the Act of 1882, which was not applicable to the facts of the instant case. This court has no other option but to reverse the judgment and the decree passed by the learned first appellate court on dated so-and-so entitled so-and-so. The consequential effect of the said judgment and decree having been set aside is that this court decrees the suit filed by the plaintiff, thereby declaring that the plaintiff has right, title, and interest over the Schedule B land, over the land described in Schedule B to the plaintiff. Number 2, the plaintiff is entitled to recovery of past possession of the Schedule B land along with the structures described in Schedule C to the plaintiff. The plaintiff is further entitled to a permanent injunction, thereby restraining the defendants, their representatives, servants, and agents from dispossessing the plaintiff from the suit house described in Schedule C to the plaintiff after the delivery of possession of the same to the plaintiff. Further to that, this court, however, is not inclined to grant the relief of recovery of area rent, taking into account that both the courts below have, taking into account the learned court below, have categorically opined that there was no landlord-tenant relationship. With the above, the instant case that's disposed, the record raised the profit prepare the records to the court. Cost 50,000. In the fact of the case, the court further imposes a cost of rupees 10,000 upon the defendant, upon the respondent, and upon 50,000 upon Mr. D.
After allowing the
So what? We should always take precedent when the appellate power, when the council has made such type of thing.
Yes, as per your lordship observation made yesterday, we have gone to the same. Our lordship, may kindly see order 13, rule 10.
Yes.
Court may send for papers from its own record or from other court. The court may, of its own motion, and may, in its discretion upon the application of any of the parties to a suit, send for either from its own record or from any other court the record of any other suit or proceeding, and inspect the same. So, my lord, this section does not deny my right to get the case record called for from the court of criminal court, because that is a court. So I filed petition Unfortunately, my lord, we have not annexed, but petition I have got, my lord. The petition, both the petitions I have got, but that was due to bona fide mistake. Their petition I have got, they have not mentioned any section or order in their petition. But if we have made our petition under order 13, rule 10
No,
of
kindly up to number 2.
number.
Every application made under this rule,
Yes.
unless the court otherwise is supported by an affidavit showing how the record is material to which the application is made, and that the applicant cannot, without unreasonable delay or expenses, obtain a duly authenticated copy of the court of such portion thereof as the applicant requires, or that the production of the original is necessary for the purpose of justice. You will mention all these things in your application.
My lord, this is my petition, and we have what we have annexed in the state petition.
No. Show me that application at order 30.
We have made.
Continue.
We have annexed those report of the expert body, and that lordship we may kindly see.
That is not necessary.
So
I'm
that
asking
was
you
obtained, that was
Mr.
obtained from the court.
Ahmad, that is- Charge sheet has been submitted. In that case,
Final report was submitted.
finally,
Final report.
So
The investigation was closed because the signatures of the plaintiff tallied with the signatures provided. So basically, they closed the investigation, submitted a final report. Against that final report, I filed a protest petition before the court of SDGM. So they want to call for the record of that case.
Yes. Yes.
in-
Very simple
along with
matter.
the final.
That is also, they have filed a petition that again it should be sent to forensic expert for re-examination, forensic examination. We said that already there is an examination from which was sent by Superintendent of Police. That is in the record of the learned criminal code. So our prayer was that that should be also called for, but unfortunately that was rejected.
no, we have seen very well, rightly rejected at order 30%. Why? Grounds are not there.
No,
There is
ground-
a requirement of a compliance with order 13
My
to
lord,
10.
actually, my lord, I have not annexed the petition.
I have seen it.
I
It
have
is there.
collected the petition.
I've got it.
No,
It's not
that
there.
grounds are there, ma'am.
There's
Kindly
no-
see that petition.
No, have you mentioned that you cannot produce the original, the authentic copy without
No,
delay?
that. I think, my lord, considering of something when material point is the opinion of the expert.
Mr. Mahmood, what requires to be done? I will protect you, but how far? All these things are not necessary.
No, other things
Let
also.
the court, no, let the court proceed with that examination. Let the court proceed with that examination. I will allow you to permit you to file an order 13 Rule 10 application in the proper manner. And thereupon the court may call for the records of that, or may direct you to produce the authenticated copy, whatever that is for the. Okay. I think that is the,
If I file a petition, that should be.
yeah, without being influenced by the earlier.
There.
The instant application under Article 227 of the Constitution has been filed challenging the order dated 26/6/2023 passed by the learned Munsif number 2 Gwalpara in title suit number 148 of the 2018. From a perusal of the said order, it revealed that two applications were taken up for consideration by the learned court below, by the learned trial. The first application was a petition number 916/2022 filed by the petitioner herein, who were the defendant, for calling for the record of
PS case number,
calling for the records of CR case number,
CR
CR case, huh?
case number 420, public
No, no,
2006.
No, it was registered as CR complaint.
No, first,
Calling for the records of CR case number 388 of the 2017, along with Ogia PS case number 21 of the 2016 and CR case number 420 of 2016 from the court of the learned here, Walpur. The second application to file is the application filed by the plaintiff, who are the respondents herein, being petition number 304 of the 2023, seeking scientific examination, seeking appointment of a commission for scientific examination in terms with the provisions of Order 26, Rule 10, and Order 20 and 10 and 10A of the Code of Civil Procedure. The learned trial court, by the impugned order dated 26/6/2023, allowed the said application filed by the plaintiff, thereby directing
I refer to what it says about the guidance. Just 55.
where
Just 55. And 56 bottom.
the look through
This is
it
just
happened. In 916 file back then. The learned trial court, by the impugned order dated 26/6/2023, allowed the application filed by the plaintiff to call for the relevant part of the register book oblique the register book. Where part of register book and the relevant part of other documents where the executants had put their thumb impression and signatures at the time of registering the deed of relinquishment from the office of the sub-register. Where is the direction for sending it for
No,
comparison?
that direction is not there. Express direction
So
is
this
not
is
there.
also
But
wrong.
in our prayer portion, my lord, it was there.
It is not there.
Yes.
So
No,
I think both should be set
my
aside.
lord, in the prayer,
We set aside this for reconsideration again.
but in
This
the
is
prayer,
not.
in the
No,
prayer,
you will have a difficulty.
but in
What
the
does
prayer
the
portion,
code do?
probably it has been mentioned, my lord, in the prayer portion of the
The
our petition.
petition is accordingly allowed and disposed. Accordingly allowed means only allowed for calling
Probably,
for.
my lord, that time the court might be thinking that after calling the register book and logbook, then my lord.
No, he has to pass that
Yes,
order to
that
the
is not
effect.
They have also not made any provision of law, but their petition.
Huh?
In their petition, they have not mentioned any provision of law.
mentioning is not
We have
mentioned, my
mentioned.
It's not fatal. Non-mentioning of a correct provision, man, it's not fatal, man.
The contents are also not there.
Non-mentioning of a correct provision is not fatal.
Yes.
But the non-mentioning of no provision is totally fatal.
Manpower will be there, man.
We set aside this entire and directing the court below to again decide this, taking into account the provisions of. I set aside this not for other purpose, only for the purpose that
Yes.
the relief have not been
Yes.
taken into consideration.
Examination part is not there.
This is an application challenging the order dated 26/6/2020, passed by the learned trial court, passed by the learned Munsit, number 2, Gwalpara, in title suit number 148 of 2018. From a perusal of the impugn order, it reveals that the learned trial court passed orders in respect of petition number 916 of 2022 and petition number 304 of 2023. This court finds it relevant to take note of that the petition number 916 of 2022 is a petition filed by the plaintiff. Is a petition filed by the counsel of the plaintiff. It is filed by the counsel of the plaintiff.
Right.
How is this permissible? Filed by the counsel of the plaintiff. Taking a direction for calling for the relevant part of the register book of the register and relevant part of other documents of the document where the executed had put thumb impressions and signatures at the time of registering the deed of relinquishment by deed number 660 of 2000 dated 19/6/2000 from the office of the sub-register Gwalpara and examine those existing signatures of the executed on those documents to expert by comparing the admitted thumbprints and signatures of the plaintiff. The petition number 304 of 2020 is an application filed by the defendant stating in the area that in respect to the said relinquishment deed, an FIR was filed by the plaintiff, which was registered and numbered as Agia PS case number 21 of 2016. against the defendant, and in connection therewith the signatures of the deed concerned were forwarded to the Director of Forensic Science, Sam Ahilipara Guwahati, for report regarding the signature of the plaintiff, and the report was stated, and accordingly the report was duly submitted to the Superintendent of Police Goalpara on 19/9/2016, which is kept on record of OKF PS case number 21 of 2016 and CR number 420 of 2016. It was therefore thought that the state application, that the records of CR case number 388 of 2017 along with OKF PS case number 21 of 2016 and CR case number 420 of 2016 from the learned CM Goalpara was required to be called for by the learned court below, by the learned court for the end of justice. This court has duly perused the order dated 26/6/2023, whereby the learned trial court have partly allowed the application filed by the plaintiff, being petition number 916 of 2022. However, rejected the petition filed by the defendant dated number 304 of 2023. This court is shocked and surprised to see that the petition filed by the plaintiff is not a petition filed on the basis of an affidavit, but rather a petition filed, the petition supported by an affidavit, but rather a petition filed by the counsel, that too on a verification. The said application on the face of it was not maintainable in view of the provisions of Order 13 Rule 10, read with Order 13 Rule 10, read with Order 6 Rule 15 bracket 4 of the Code of Civil Procedure. Under such circumstances, the said application ought to have been rejected by the learned trial court. This court have also taken note of the petition number 304 of 2023, wherein it is seen that the entire case records of CR case number 388 of 2017, along with OGR PS case number 21 of 2016, and the GR case number 420 of 2016 have been called for. There is no mention in the said application as to why the entire case record was necessary, inasmuch as the said application was only the said, inasmuch as the perusal of the said application only pertained to the report which was submitted in Auggia Police Station case number 21 of 16. The plaintiff, the defendant, therefore ought to have asked for that document and nothing further. Be that as it may, this court also finds it relevant to take note of that it is the mandate of Order 13 Rule 10 bracket 2 of the Code of Civil Procedure 1908 that the certain prerequisites are to be satisfied when an application is filed. Under such circumstances, this court sets aside the order dated 26/6/2023 passed by the learned court of the Munsif number 2 at Goalpara in title suit number 148 of 2018. Be that as it may, this court, however, grants the liberty to both the petition plaintiff and the defendant to file appropriate application in terms with the provisions of law, seeking if they require any document to be brought on record by the learned trial court. This court have also taken note of that by an order dated 23/8/2023, further proceedings in title suit number 148/2023 have been stayed. The said stay order is vacated and the parties are directed to appear before the learned trial court on 5th of April 2024. It is simple.
Oh, like, highly obliged.
I am surprised your lordship is so much keeping memory of all these orders, sector rules. Very praiseworthy for us. It's proud for us.
None appears on behalf of the appellant on court. It is also seen on record that on the earlier occasion also, none has appeared on behalf of the appellant. Considering the above, the appeal stands dismissed for non-prosecution. The record, the registry is directed to forfeit prosecute the record to look to the court. Oh, this matter, somebody died. Who died?
I am the plaintiff.
Ah.
I filed the suit against the defendant for right title incident and for written declaration that defendant is the party to occur. So it was process expertise. It is the defendant. I have exhibited the document that exhibit 1 was. Both the court below have dismissed my suit only on the ground that it is only the certificate copy. Portion has not been exhibited.
What all? What is exhibit 1?
Exhibit 1 is the sale details. Because I have inherited the suit from my father. It was in the year 1966.
So you want the 30 years presumption. That is your case. And what happened? Whether the first appeal was justified in rejecting the application filed under Order 41 for adducing evidence so as to prove the original sale deed, certified copy of which was not as exhibit 1.
There is no
So you filed an application under Order 41
Yes, sir.
that was rejected
rejected notice before the delivery to judgment. But as per Supreme Court
before delivery of judgment.
Yes.
Oh, that is like that. It will be done as per Ibrahimuddin,
Yes, sir.
2012, 8. You have that judgment.
I have the.
You thought
It
that
will-
matter
it will
would not
it
be
will considered at the stage of hearing.
understood. Yes, you have to say that.
My lord, so far their application, my lord, from the records, it is not seen that they have filed an application.
No, let us see. Where is that impugn order?
Order is page 11, 14, Appellate
Hmm?
Court judgment. Page 14.
It is the- You had a respondent, you had a plaintiff.
I am the plaintiff. It has been filed.
Viewing the evidence of the plaintiff has Tell deed of 56.
56.
So if it's a 56 tell deed, what was the problem? Whether that the presumption would not come into play?
That will come.
A certified copy of a document can be
And
reviewed.
it was not objected to because suit was expertise.
Understood. And what is the proof required?
Not required.
No. 100% proof is required, but prima facie.
Fine.
The contents of a document must be proved in origin. And have you filed an application under Order 41 Rule
Yes,
27?
sir.
Where is it?
It is,
What
It
is
is
it?
in the LCR lordship, page 3.
All matters.
That was rejected by order at 5/6.
And it has been pending here for last 14 years. Page 3. Yes, Mr. Rajkumar Kuya, what are you saying?
My lord, from the papers available with me, my lord, there is no record that they have submitted an application under Order 14 Rule 27.
But there is an order passed by the learned trial first appellate court reject.
Rejecting it. If it is so, then there is no question.
Not only that, there is also record that you have filed objection. This is the petition. No, but that is one thing. On the basis of the certified copy, why the suit could not have been declared?
Ought to have been defeated.
Ought to have been declared. But that is not the question of law.
Ordinarily,
The only thing is remand.
the case of
You said to go into that issue of say about the 90, na? Evidence Act?
Yes.
90.
presumption of success.
Presumption of 30 years is 90. You can take up that plea. The instant appeal under section 100 of the CPC of the Code of Civil Procedure is directed against the judgment and decree dated
9/12/2009.
9/12/2009, passed in title appeal number 32/2008, whereby the learned first appellate court, that is the court of the civil judge Dhubri, had upheld the judgment and decree dated 27/6/2008, passed by the learned Munsif number 1 Dhubri. This court, by an order dated 29/2010, had admitted the instant appeal by formulating a substantial question of law, which reads as under: whether the learned first appellate court was justified in rejecting the application filed under Order 41, Rule 27 of the CPC for adducing additional evidence, so as to prove the original sale deed, certified copy of which was marked as Exhibit 1. Question. This court had duly taken note of the records of the first appellate proceeding, wherein it is seen that the application under Order 41, Rule 27 was filed by the appellant, and upon being objected, the said application was rejected by the order dated 5/6/2009. Thereupon, the appeal was taken up for hearing, and by judgment, impugned judgment and decree dated 9/12/2009, the said title appeal number 32/2008 was dismissed. The rejection of the application under Order 41, Rule 27 of the CPC prior to taking up the appeal for hearing is in direct conflict with the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, isn't it? Reported in 2012 8 SCC? Then, till there I have stayed. Then, page.
Four, 148.
140. Heading if now it didn't. Two 2012.
8 SCC, 148. There are 38 days of conviction.
Paragraph 49 to 52 of the state judgment being relevant is reproduced herein under. Taking into account the well-settled principle of law as held by the Supreme Court in the above judgment, above quoted paragraph, the judgment, this court is of the opinion that the learned trial First Appellate Court completely erred in law in dismissing the application under Order 41, Rule 27 of the CPC by the order dated 5/6/2009. In addition to that, this court also finds it relevant to take note of that the said suit was proceeding ex parte. The document which the plaintiff wanted to adduce as Exhibit 1 is a certified copy of the deed of sale dated 27/9/1956, bearing deed number 3311. The learned First Appellate Court the learned trial court as well as also the learned first appellate court did not also take into consideration the provision of section 90 of the Indian Evidence Act 1872, wherein a presumption can be drawn in respect to such document. In addition to that, this court also finds it relevant to take note of the judgment of the Supreme Court in the case of RVE Venkatachala Godar versus Orulmigu Visveswara Swamy and BP Temple, reported in 2003 8 SCC 752. Wherein the Supreme Court also finds it relevant to take note of the judgment of the Supreme Court in the case of Ramesh Chand Ardhawatia versus Anil Panjwani, reported in 2003 7 SCC 350. wherein the Supreme Court, at paragraph number 33, observed as to how a suit has to be decided, wherein there is no written statement. The Supreme Court observed in the said judgment that in absence of denial of the plaintiff averments, the burden of the proof on the plaintiff is not so heavy. A prima facie proof of the relevant facts constituting the cause of action would suffice. And the court would grant the plaintiff such relief as to which he may in law be found entitled. It was, however, also observed that yet the trial court should scrutinize the available pleadings and the documents, consider the evidence adduced, and do well to frame the points for determination and proceed to construct the ex parte judgment dealing with the points at issue one by one. Merely because the defendant is absent, the court shall not admit evidence, the admissibility whereof is excluded by law, nor permits its decision being influenced by irrelevant or inadmissible evidence. The said paragraph 33 being relevant is reproduced hereunder. Taking into account the above, this court is of the opinion that a substantial question of law which have been formulated duly arises, is duly involved in the instant appeal. And consequently, this court therefore sets aside the impugned judgment and decree dated so and so 9/12/2009 for the reasons aforementioned, passed in title appeal number 32/2008, passed in the above, passed in so and so, and remands the matter back to the learned first appellate court, that is the court of the civil judge Dubri, to decide afresh the said appeal by taking into account the above observations. The LCR so called for is returned. The registry shall return the LCR forthwith so that the matter could be taken up by the learned first appellate court at the earliest, taking into account that this is a very long pending dispute. This court have also taken note of that both the parties are duly represented. As such, this court fixes the matter on 22nd of April 2024 for appearance of both the parties before the learned first appellate court.
Okay.
Yes.
It's concurrent finding. I'm coming against concurrent finding.
So you have withdrawn, surrendered yourself
No, no.
before saying a word.
No, no. It's that.
Yes, yes, others may go.
Yes. The plaintiff case is that it purchased land.
Huh?
Purchased land. Plaintiff case is that the land is purchased land.
He had purchased the suit land.
Yes.
Then?
And a portion of the land has been enforced by me. I am the defendant.
You are the defendant.
Defendant.
He is the plaintiff. Okay, then?
Thereafter, if trial was proceeded, now my substantial question is that one of the issues arises, that is the core issue, because along with purchase, I have taken the plea of adverse position. That has not been no issue and nothing else.
Where is your plaintiff?
Plaintiff
Written
certificate.
statement?
Written statement,
Written statement where?
page 14.
Yes. Where is your statement for adverse possession?
Paragraph 12, page 18.
What does it say?
Letter nine before bottom line has the answering defendant state that if the suit then falls in dark number 19 of KP Patta number.
Para 12 says that the statements made in para 6 of the plaint are correct
Let's ask
and denied. Wait. Defendant has been possessing the land since 19, which is a common land.
Yeah.
Which, without any hindrance and disturbance from any corner whatsoever. Isn't that your case? Is this your case or not? That this is a common land.
there is the issue regarding identification of the land. And therefore,
No, therefore, the question is, how can there be an adversity of adverse possession in the land if it is not adverse to the owner?
later portion is there.
Where?
If because 191 and 190 confusion is regarding that student. 191 is document. 190 is it is Patta land. If the answering defendant states that if the student falls in dark number 190 of KP Patta number 06 of village board society, and then the answering defendant has got adverse possession as he has been occupying and possessing its name since 1988. The plaintiff at the time of purchase could not take over possession of the same, and as such, the plaintiff has no right, title, interest, and possession over the suit land, and as such, the suit is liable to be dismissed.
Kindly come to paragraph 9.
Statement paragraph 3 of the plaint was incorrect and denied by the states that the answering defendant is owner of land measuring 1 kata covered by dark number of village. The state land was purchased by defendant number 1 from by executing registered since the date of purchase the defendant number 1 by
So you say that you have purchased from somebody else.
that is lab pertaining to dark number 189.
And what about this land?
This is dark number 190. Woodland is dark number 190.
Kindly see again 191 again.
191 is government.
Government land. We are concerned with tag number 190.
Now,
So it's the plea of adverse possession. You
190.
don't have a plea of adverse.
190, I have taken paragraph 12. There is my evidence.
Your entire case is on that.
The single. That
No,
is the
nothing. For adverse possession, you require the basic thing. And further to that, your question has to be on purpose. But your pleadings are not there. Without pleading, there can't be any evidence.
readings of two direct professor adversity. Evidence also the same there. Beyond that,
You can't lead beyond that. You can't say tomorrow, becoming clever, oh, the plaintiff came over, I threw him out. I said that you cannot do so. This is the usual pleadings we see in network. He came on such and that. Even Supreme Court says that when you are claiming adverse possession, you have to say the date
Yes.
when it became adverse.
Yes.
There's the time space.
from the specific time. And
the Baki would make her he would be put up. It requires earlier matter is not this matter. This matter also should go immediate. But the earlier matter really could it have been pending for the police should have taken 2 minutes. Earlier matter is just 2 minutes. Don't even require much thing to think. Same here. It have the last. The instant appeal under section 100 is directed against the judgment and decree dated 13/9/2010 passed by the learned court of the civil judge number 1 Kamrup, Guwahati, whereby the title appeal number 2/2005 was dismissed. They were affirming the judgment and decree dated 14/12/2004 passed by the learned civil judge, Junior Division number 2, Guwahati, entitled suit number 136/2000. The instant appeal was admitted by an order dated 6/11/2011 by formulating the following substantial question of law. Whether, in view of the specific pleading and evidence led in that respect, that the defendant had been possessing the suit land since more than 12 years adverse to the true owner, the learned courts below were justified in not adjudicating the said 4 issue while deciding issue number 2 and 3. It reveals from the record that the plaintiff herein, the respondent herein, who is the plaintiff, had filed a suit being title suit number 136 of 2000, seeking declaration of right, title, and interest over the land described. Which land?
Right title was sought with regard to the
Oh.
Schedule A land
Over the Schedule A land.
and evicting from Schedule B part of it.
And for recovery of khas possession of the Schedule B land. And for permanent injunction. The basis of the claim of the plaintiff was the registered deed of sale bearing deed number 5168 dated 26/9/97, whereby the plaintiff purchased 2 katha 10 lechas of land from the original owner. The plaintiff thereupon took possession of the said land and erected bamboo fencing further to that, the plaintiff also constructed 3 actually houses with CIC roof, bamboo post and tarja walk, and let out to different tenants. It was alleged in the plaint that the defendant number 1, whose land is situated on the northern side of the plaintiff's land and covered by dark number 189, taking advantage of the plaintiff's absence on 10/10/99, forcefully entered into the plaintiff's land and started construction of one Assam type house on the extreme southwestern corner of the plaintiff's land adjacent to the road. The said area which the defendant number 1 had taken possession, as alleged in the plaint, is at measured 6.5 lechas, which have been described in Schedule B. Thereupon, the plaintiff filed the suit seeking for the relief as already mentioned. The defendant filed a written statement claiming that the defendant had purchased 1 katha of land in dark number 189 of KP Patra number 6 from one Mohammad Harisuddin Ahmed on 25/1/95. It has also been mentioned that the defendant have been occupying and possessing a plot of land measuring 16 lechas covered by dark number 191 of village Borsozai under Beltola Moja in the district of Kamrup, Assam since 1988. Further to that, the specific case of the defendant that he had been in possession of the schedule of doc number 190, which is the suit doc, since 1988. And the plaintiff who purchased the land in the year 1997 could not take over the possession. And as such, claimed adverse possession. And as such, raised the plea of adverse possession. On the basis of the said pleading, as many as 7 issues were framed. Though there was no specific issue on the plea of adverse possession or as regards the suit being barred by limitation. Neither any step was also taken during the course of the plea trial by the defendant for addition of the said issue. Be it as it may, the learned first trial court, by the judgment and decree dated 22/12/2004, dismissed allowed the decree the suit. By holding that the defendant failed by holding that the plaintiff duly proved his case, whereas the defendant failed to prove his defense. Being agreed, an appeal was prepared by the defendant before the court of the civil judge number 1 Kamrup, which was registered and numbered as title appeal number 2/2005. The first appellate court, by its judgment and decree dated 13/9/2010, affirmed the decree passed by the judgment and decree passed by the learned trial court and dismissed the appeal. And it is against this dismissal of the appeal by judgment and decree dated 13/9/2010, the present appeal has been filed before this court, and on the basis of which this court had formulated have admitted the appeal by framing the substantial question of law as above noted. This court have duly heard the learned counsels appearing on behalf of both the plaintiff petition appellant as well as the respondent. The question therefore arises before this court as to whether the said substantial question of law so formulated is involved in the instant appeal. This court had put a specific query upon the learned counsel appearing on behalf of the appellant as to on what basis the learned on what basis the appellant claims on what, as regards what are the pleadings on the basis of which the appellant claimed that the plea of adverse possession was taken. The learned counsel referred to paragraph number 12 of the said written statement. This court, having taken note of the said paragraph, is of the opinion that the paragraph not only is vague, but also lack material particulars which are required for raising the plea of adverse possession. It's a trite principle of law that for the purpose of constituting the plea of adverse possession, you require the three elements. What are those?
My lord, that date of my lord, date when they have entered, my lord, that is to be quoted.
No, there's the three elements. No, it says in Latin word.
Oh,
Let
yes,
us
my lord.
also become more
Yes, my lord, yes, sir. Yes, my lord.
Nivek, or what is all
Yes,
this?
yes, yes.
For the purpose of constituting the plea of adverse possession, the person claiming adverse possession has to show A, on what day he came into possession. B, what is the nature of his possession. C, whether the factum of possession was known to the other party. D, how long his possession has continued. And E, his possession was open and undisturbed. It is also well settled that mere possession of land would not ripen into a possessory title, and the possessor must have animus possidendi and hold the land adverse to the title of the true owner. And moreover, he must continue in that capacity for a period prescribed under the Limitation Act. Further to that, the concept of adverse possession contemplates a hostile possession, that is, a possession which is expressly or impliedly in denial of the title of the true owner, in the instant case, more particularly, perusal of the paragraph number 12 of the said application of the written statement, it will be seen that no such pleadings are available. And the plaintiff have merely stated, the defendant have merely stated that he have been possessing the land since 1988, and in the year 1997, The plaintiff purchased the land and could not take over possession. There is no, the said pleadings are also bereft of material particulars. Considering the above, this court finds that the substantial question of law so formulated does not arise, is not involved in the instant appeal, for which the instant appeal stands dismissed with the cost of which, and this court imposes the cost of rupees 10,000 upon the appellate. The registry shall return the forthwith transmit the records to the court.
It's neck B, neck come and neck picket.
Very active.